Commercial matter. Item number 1, Sundar Niyogi versus Jantu Kumar Niyogi.
Millard, this is my application, Millard, under
I
section
prefer responding
29A, Millard. It's a second extension, Millard. It's within time. The period is expiring on 7th of February 2024.
Show me the name of the arbitrator, please. Which page?
200.
Millard, Lordship will take page 44. Millard, family dispute, partnership. Millard, there are properties of
What is
partnership.
what is the stage of the arbitration?
Millard, valuation has been done in most of the properties. 2 properties have been outstanding. It has to be sold. Shares are admitted, Millard.
No. What is the stage of the arbitration?
Millard, pleadings completed. Millard, valuer appointed, Millard. Inspection, valuation complete. This were 5 properties. 2 properties are outstanding. Then there will be a public auction for selling the properties and we get the proceeds less the liabilities.
No, you're talking about the merits of the matter.
No,
I'm
that is
asking you,
the
what
state.
is it arguments or is it evidence?
It's an
What is it?
arguments. Arguments. state.
Yes, you say that.
Arguments. state.
How am I interested in whether the valuation, how much is done? How
Millard,
much is
the
not done?
arbitrator, Millard, since there's 7 properties, Millard, it fell from the arbitrator. If Millard won a 12 months extension, he can get because he has
You're the claimant.
his family claim. It's family dispute between the parties.
And show me the first extension, please.
Page 46, 7th of February 2023.
This is a second extension for the arbitrator's mandate under section 29A within brackets 4 of the 1996 Act. Stop. The first extension was given on 7th February 2023 by a coordinate bench. Stop. Next. Learned counsel appearing for the petitioner within brackets claimant in the arbitration, close brackets, submits that the mandate is subsisting, that the mandate was subsisting on the date of making of the application,
Yes.
as on the date of making of the application. Stop. The mandate is due to expire on
7th of February 2020.
7th February 2020,
2024.
2024.
24.
Stop. Next. Council also prays that the extension, that a substantial extension be given, considering the nature and extent of the family dispute, considering the nature and extent of the subject matter of the arbitration, which is a family dispute. Stop. Next. APCOM of 30 of 2024 is accordingly allowed and disposed of by extending the mandate of the learned arbitrator for 6 months from 7th February 2024.
May I file my affidavit?
The affidavit of service is kept on record.
Grateful. Much obliged.
Item number 2, the State of West Bengal and others versus Mrs. BBM Enterprise.
Lordship, I am appearing for the applicant. Lordship, Mr. Shakku Shen is appearing. Lordship, may it be passed over.
Lordship, I'll be praying for an affidavit to be filed in this matter. In short, Lordship, one.
What is the
I'll
prayer?
tell you,
1
Lordship,
minute.
is for further-
Why? It's not your application. Yes,
I'm
Ms. Addu, what
I'm
is the
The application is for further cash security in respect to the outstanding amount. Lordship, there are dues of as
further
in
cash
January.
security?
Yes, in respect to the AP 808 is the 36-2 application that was filed by the overt debtor. Now, in respect to my
No, I'm looking at GA4. What is
yes,
that?
this is my application. Originally 12 crores and odd was due, and as on date it is 14 crores and odd, out of which 9 crores has already been deposited by way of security. Lordship will remember application was made and Lordship was pleased to pass an order for putting in the security. They have put 9 crores. Now, as on date, out of the balance amount, that is 5 crores and odd, I'm seeking that the award debtor may put further security and I be given liberty to withdraw it.
How are you getting this 5 crores
that
outstanding?
calculation I have already indicated. Lordship will kindly take the application.
That's GA4.
GA4, the application, Lordship, the calculation is appearing in volume 2, Lordship.
Volume 2.
Volume 2 of the.
There's only one volume in front of me.
May I indicate, Lordship? The calculation, Lordship, will find at
Miss Addo, are you not ready with the
Lordship,
matter?
Lordship, with the file, I was seeking for a passover. Lordship, Mr. Sen.
Why? Because you assume that you presume that the court will grant you the Passover.
Lordship,
Yes, list this matter tomorrow for learned counsel to get
Lordship,
ready
may
in the
I
matter.
indicate the 5
Next.
Lordship,
Item number 3, Bishojit Chakraborty.
This is my Section 11 application. On the last occasion, my lord, 2 points were taken by Mr. Mitra. One, my lord, that it's not a commercial dispute. And secondly, there is no proof of service of Section 21. In respect of proof of service of
Proof
Section...
of service and not a commercial dispute.
Not a commercial dispute, my lord. In respect of proof of service, my lord, it was the AD card, what was annexed, my lord, that was by mistake. We have the AD card with us, which shows service.
Of
Now,
the 21.
Of the Section 21 notice. But, my lord, I'll not trouble your lordship with that because I have actually thereafter taken proper instruction. In my lord, this is possibly I should not take much time of your lordship. My lord, kindly allow us to file it in non-commercial division. Withdraw and file because I'll not like to trouble your lordship and argue on whether it's commercial, not commercial. I've not been able to satisfy myself.
No, the other point was that it's not a
Not
commercial dispute.
So, my lord,
That's
kindly
right.
grant us
Yes.
liberty to file in
Yes.
non-commercial.
Yes, Mr. Mitra.
No difficulty. He's obtained the injunction from the commercial court.
That's why we filed it in the
He'll be in
commercial
some
division.
difficulty over there, but I cannot stand in the way if he wants
Yes,
to withdraw it.
we can thrash out these points later at an appropriate stage. The 2 points of objection taken on behalf of the respondents, namely that the Section 21 notice was not served on the respondents, and second, that the dispute would not fall under does not fall under a commercial dispute, is answered thus. Stop. Next, learned counsel appearing for the petitioner does not have any objection to having the matter listed before the non-commercial division of this court. Stop. Counsel also waives. What is it? What were you waiving?
Well, I'm not waiving, my lord. I've just said that in respect of service.
No, waiving as in WAV, not WAIV. Yes.
Milord, with your ladyship's permission, may I interrupt? Milord, the submission made was he wanted to actually withdraw and file in the non-commercial.
If my lord transfers,
because
my
there's
lord,
no
I have no
automatic-
difficulty neither.
Milord, I'll leave it.
Withdraw and file. That's fine.
Very well, I'll-
Yes. A learned counsel appearing for the petitioner also produces a document on the first point, that is proof of service of the Section 21 notice on the respondent, to the respondent. Stop. Next, the fact whether the Section 21 notice was indeed served on the respondent can be gone into at an appropriate stage. Stop, comma, for now, comma, the petitioner is given leave to withdraw the present petition and file the same before the commercial division of this court.
Non-commercial division, my lord.
Non-commercial division of this court. Stop. AP 729 of 2023 is accordingly dismissed as withdrawn with liberty to file afresh.
Grateful, my lord.
Next.
Four, BGM and MRPL JMCT.
May I start?
My lord, before my learned senior friend starts, your lordship, my lord, I will be humbly praying for a short Passover, my lord. My lord, Mr. Basu is on his legs, my lord. My lord, short Passover, my lord. I'm praying for, my lord.
He has completed his submission.
My lord, my lord.
No. Mr. Ghosh, please. Otherwise, I will give you the chance. Please argue, and then I will go to Mr. Ghosh. No Passover business here. Yes, you can argue whatever points are left. I thought he had made extensive submissions on the. This is that.
Documents we would be relying on, your lordship.
No documents. Yes, Mr. Ghosh. Then you should have been ready in the matter. Yes.
Milord,
Your work is not to take time. Yes.
Milord, may I just formulate 4 points, Milord? Then I show
Microphone, please.
May I formulate, Milord, 4 points, Milord? Then I show the documents, Milord. A, Milord, there is no mandate, Milord, in the settlement dispute clause to refer the disputes to arbitration. There is no mandate.
Yes.
Milord, the clause, Milord, clause 37 and clause 13, there are 2 clauses in, Milord, the contract notice inviting tender and the work order. Milord, those are, Milord, similar or identical, Milord? The section 21 notice invokes, my lord, clause 13, not clause 37 as showed by my learned friend, my lord. However, my lord,
Is this not the matter where this bias was being argued?
no, no, no,
No,
this is
this
not
was
bias, this
different.
is may and shall.
Yes, 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 that's right. No, you're saying no arbitration clause.
I am saying, my lord, the clause says, my lord, may be sought through arbitration. May be
Yes.
sought through arbitration. Lordship will find that at page 106 as well as page 164 and 65 of, my lord, Lordship's
106
brief.
or 107?
107, my lord.
Clause 37.
Yes. But the invocation, my lord, which is done, my lord, by a letter, my lord, that invocation clause, my lord, which is, my lord, 21st of
No,
July.
1 minute, please. So settlement of disputes, first is your construction of this.
First is construction.
Yes.
It's, my lord, may be sought through arbitration.
Yes.
There is no mandate to refer the disputes to arbitration. It's may.
1 minute, please. Where do you find that?
Miller Lordship will kindly take the clause once at page 107. At 108. In case of the parties other than the government agencies, the redressal of the disputes may be sought through Arbitration Conciliation Act as amended by the Amendment Act of 2015.
Yes.
Now, my lord, my learned friend, my lord, kindly Lordship will kindly come to page
So
100.
you're saying that this is the clause which is binding?
My lord, may means, my lord, a further consent is
No,
required.
no, no. This is the clause which is binding other than government agencies.
Yes, other than government agencies. My
Yes.
lord, he falls within other than government agencies. Lordship
Yes.
will kindly take page 107 once.
Yes.
First clause is a settlement of dispute. It is
Yes.
incumbent upon the contractor to avoid litigation and disputes during the course of execution. However, if such dispute takes place between the contractor and the department, effort shall be made to settle the disputes at the company level. The contractor should make request to the engineer for settlement of the disputes within 30 days arising out of the case of dispute, failing which no disputes or claim of the contractor should be entertained by the company. The effort shall be made to resolve the
Mr.
dispute.
Ghosh, I've read all this.
Yes. Now,
So-
Milord Lordship, he relies on, kindly take
No,
the
but
line.
this will not apply to you because you're covered by, or the parties are covered by, in case of parties other than
Other.
government
Now,
agencies.
Milord, my learned friend relies on one other sentence. If the dispute still persists, settlement of the dispute shall be resolved in the following manner. So, Milord, there is a shall. Dispute shall be resolved in the following manner. A applies, Milord, to the government agency. So, intersect between the two arms of the government or government agencies or a state or the instrumentality of state. We are not covered. B, which is, Milord, the empowering clause permitting the parties to go to arbitration, has the clause
I
may
can't
be
find
sought.
B. Where is B?
Milord, second part I say, Milord, in case of non-government
Yes.
agencies,
Yes.
page 108.
Yes.
In case of parties other than non-government agencies, which is my learned friend, Milord, the private parties.
No, so
It-
whatever has come before this,
Yes.
in case of parties, that is not relevant for.
That is not relevant, Milord, for me.
Yes.
For us, Milord, is maybe sought through arbitration.
Yes, because
is
you
the
are,
clause.
because the petition is a non-government
It is a
agency.
non-government party. Whether, Milord, this may, Milord,
Yes.
is a mandate to refer to arbitration. This is the
Yes.
short point. Lordship will look at the clause and Lordship will decide.
Yes. What was your second point?
Milord, the second point, Milord, is, Milord, this, Milord, cannot be termed as, Milord, a mandate because in absence of shall or the words, Milord, shall be referred to arbitration, the decision or award passed by the arbitrator binding on the parties are absent in the clause. These
Yes.
are, Milord, one of the ingredients of the arbitration clause. Now, Milord, in Milord, the decision where, Milord, in a conciliation clause there is a shall, or in the other, Milord, clauses above that there is a shall, but the arbitration clause is capped with may, Milord. Milord, there's a decision of, Milord, Bombay High Court, considering all the decisions, has come to a conclusive finding following all the Supreme Court cases, Milord, that, Milord, it is not a mandatory arbitration clause. Because, Milord, clause 32 of the contract, Milord, has, Milord, a clause of legal jurisdiction. The parties are not remediless. They can file the proceedings by way of a civil suit because Section 9 of the Code of Civil Procedure permits, Milord, to entertain, Milord, all action which is not expressly or impliedly barred. Now, Lordship will kindly take, Milord.
Clause 32 of the contract, that's
Clause-
106.
Yes, clause, Milord, kindly take, Milord, page 44, Milord, of your Lordship's brief.
No, no, clause 32 is not, does not say anything about suit, filing of suit.
I'm sorry, Milord, 48, Milord. I stand corrected, 48. Kindly take page
48.
48. Yes, legal jurisdiction.
No, but that is part of the same contract.
Yes, yes. These are all, my lord, part of the same contract annexed by him. He has invoked, my lord, clause 13 by a letter, but 37 is similar to 30. Pleading also, my lord, is that he is invoking clause 13, not 37. That's how he is pleaded.
Yes.
Matters relating to any dispute arising out of this tender and subsequent
Yeah, I've
contract
read it,
awarded.
yes. And which is the clause which he has invoked?
My lord, that's clause 13. That's at page 64.
If it's clause 13, then why are we on 37?
My lord, he is saying, my lord, he has shown 37, but it's same. It's same. There is no, my lord, distinction between the two clauses.
Yes.
These are, my lord, same. Lord, you will find that at page 99, my lord, that particular clause is same.
Yes.
So, my lord, in this situation, my lord, there's an option given to the party, my lord, either to go to arbitration or not to arbitration. And a further, my lord, consent is required. Lord, you will kindly have a look at, my lord, Bombay High Court. Just, my lord, I just indicate the paragraphs and, my lord, sit down, my lord. Kindly have a look at, my lord.
Jagdish Chandra?
No, Jagdish Chandra, I have already placed,
Yes,
my lord,
yes,
8
yes.
subparagraph 4. Lord, you will kindly have a look at 2020 SCC Online Bombay 693, Miller, which follows, Miller. Kindly have a look at noted copy. The clause, Lordship, will find at paragraph 5. Shall, may, Miller, it had both, Miller. All disputes under the agreement, that's, Miller, continuation of paragraph 5. All disputes under this agreement shall be amicably discussed by resolution and designated personnel of each party. And if such disputes cannot be resolved within 30 days, the same may be referred to arbitration. Now, Miller, it has a further clause B. The disputes under the agreement shall be referred to arbitration as per the Arbitration Conciliation Act as amended from time to time. Now, see, subject to that clause 32, Miller, clause which I showed at page 48, subject to the provision of the clause, the courts in Pune shall have exclusive jurisdiction and the parties may pursue the remedies available in law. Now, Lordship will straight away come to paragraph 39. Paragraph 39.
Excuse me.
Where, Miller, may and shall, Miller, has been, Miller, interpreted, Miller. Then Lordship will, paragraph 39, following to Supreme Court judgments, Miller. Then Lordship will kindly take 41 is the ratio. That in the same vein, if clause 17A of the software distribution agreement is looked at, it can be noticed that the parties to the agreement use both the words shall and may in the same clause. The parties were aware of the clear difference between the words, and it is to be assumed that they choose the words to provide an indication to intend to make the arbitration possible only upon a fresh consent. 41, I'm showing. Now, Miller, this is again, Lordship will now take, Miller, paragraph 44. It is clear from subclause A of clause 17 reproduced above, the parties have agreed to a specific procedure of settlement of disputes between and under the agreement. They have agreed to designate and appoint a respective personnel to amicably resolve and settle the disputes. And if the disputes are not amicably settled within 30 days, the next step would be that they may refer the disputes to arbitration set out in B of clause 17. Now, Lordship will straight away now take 51 and 53 is the fine. And it was ultimately held, Miller, it's not an arbitration clause. Mandate, Miller, there is no mandate to go to arbitration. That Lordship will find in paragraph 54.
Very well. Yes.
Now, Millard, this was Millard prior to Millard Bidra Dolia Millard and Millard Baban Rao. Now, Millard subsequent Millard to Millard Bidra Dolia and Baban Rao, this has been followed by a single bench of the Bombay High Court, and it has been said, Millard, it has been observed, Millard, that Millard, this judgment has not been diluted, Millard, in view of the finding, because Bidra Dolia has a line where there is a doubt, please refer. So, Miller, that is Miller. Lordship will kindly indicate this is Miller 2023 SCC online Bombay, page 39. It was my duty to show because it is prior to Vidya Dolia, Miller. Lordship will kindly have a look at Bombay. Yes, I'll give you a copy. Lordship will kindly have a look at paragraphs where Miller, Baban Rao, everything is considered. Paragraph 14, 23, and 35 and 40.
1423.
14 Miller, paragraph, Lordship will take paragraph 23, which refers Visha International and Baban Rao, it considers, which cited by my learned friend. Jagdish Chandra is the sheet anchor of all the judgments. That's paragraph 32. 35 is Wellington Associates. And paragraph 40 says a fresh consent is required. Tax ratio is at paragraph 40. I need not, Miller.
And Babandra, I found it 23, where Vidya Dolia is also.
In 23, Vidya Dolia, Miller, Dula Figura is Miller, Baban Rao, Visa International are in paragraph 23. Jagdish Chandra is on Miller, paragraph 32. And Miller, Wellington Miller, which I cited on the first day, is paragraph 35. 40 is the ratio. And where there is a doubt to defer, Vidya Dolia has also Miller. Kindly have a look at Miller considered.
Vidya Dolia is which paragraph?
Miller, para 41 Miller.
Which judgment?
Para 41. Copy है check कर दिए दो. এটা quick kill GTS तो के copy दिए देना है ना. para ठीक है जो के दिए दो वो दाई नहीं बोले तुम ही देवे ना कोनो पता नहीं. So quick kill has not been interdicted. Well, similar is Miller the view of our coordinate bench also. And Miller, the sheet anchor, Jagdish Chandra has been followed in all Miller, either the Bombay or the subsequent Baban Rao, and Baban Rao relies, saying without shall you cannot go to arbitration. আমাদের এই সিঙ্গেল বেঞ্চটা দিয়ে দাও জাস্ট সারাপটা সারাপ জানি ওকে
এটার প্যারাগ্রাফ গুলো বলো।
para 41
না না কোনটা?
25 23 14 41
Wellington is the one of the Bombay High Court.
Wellington is this Supreme Court single bench Miller of 2000 Miller, which I have given Lordship a copy on the first day. First time Miller, the issue following Miller, the 76 Supreme Court Miller, which says Miller, may Miller, only thing you have to have is a shall. And Miller, our single bench Miller also Miller follows and holds so Miller.
Very well. That is all, Mr. Ghosh.
And in fact, Miller, there is a one Mohanodi coalfields. In between the coalfields, of course, the clause says may go to civil court, but here is may go to arbitration. Miller, the judgment of the Supreme Court says Miller, in no uncertain terms, Miller, paragraph 16, if your Lordship considers.
Which one?
Miller, this is Mohanodi coalfields versus IVR, 2022 SCC online 960. Same clause now. Kindly have a look at Mohanodi coalfields Miller, which is Miller. Paragraph 7 is the clause Miller. Kindly have a look at paragraph 7.
Have you not cited this before? Paragraph?
7. No, I have not cited it,
Yes.
Miller. I had said Miller, there's a judgment Miller, which I did not have. Paragraph 7 is the clause. First clause is similar. Second clause say Miller, disputes one has to go to court. Here is clause 32. Maybe arbitration going to court. Now, Lordship will kindly have a look at paragraph 16. I am only places it.
But here the clause was very different.
Yes, clause was different, but kindly have a look at paragraph. The intention to go, Miller.
Yes.
The communication merely indicates a desire on behalf of CIL to have the disputes related to work contracts settled by arbitration. Even a desire will not do. It requires both the parties to arrive at a further agreement to proceed in arbitration where the dispute arises. Therefore, in view of the principle laid down in Jagdish Chandra Supra, a line of precedent, clause 5 of the aforesaid communication cannot be construed as an arbitration agreement between the parties and the respondent in terms of section 7 of to compel the appellants to appoint an arbitrator. Here, my lord, there is a specific case. My lord, learned friend, my lord, in all fairness, should have shown the order in the section 9 court. First order he has shown. Second order in the section 9 court, where, my lord, the section 9 court, my lord, has upheld, my lord, my lord, objection in relation to order in relation to, my lord, that there is no subsisting valid arbitration clause. My lord, I have not accepted. Rather, I go to section 9 court and, my lord, try, my lord, argue, my lord, saying it's not a valid arbitration clause. That is, my lord, an order of 4th of January 2014 after the filing of the petition. Of course, my lord, this was not placed, my lord. Now, my lord, kindly, my lord,
2014?
takes 2024.
Yes.
My lord, this clause 13, naturally invocation was clause 13. So clause 13 was, my lord, placed, my lord, and, my lord, the single judge said, my lord, that the commercial court says it's not an arbitration clause, which lordship will find, my lord, at page 6 of the judgment. In view of the discussions made herein above, last line, I am of the considered view that there is no arbitration between the petitioner and the respondent. The petitioner therefore could not have.
And what is the miscase for?
Miscase is for, my lord, section 9 not to invoke, give further effect to the show cause notice or take further steps.
So on Mr. Basu, section 9.
On Mr. Basu's section 9, my lord, arising of the same contract. The first contract, my lord, has an order that the parties should abide, take steps in recourse to law in arbitration within, my lord, 3 months' time.
Yes.
That order was of May 2023, my lord. The petitioner did not do so, did not give an invocation, but section 11 was not filed. This is the second order where I take the point and I am successful, my lord. So, my lord, I have registered the arbitration saying that there is no arbitration clause. So, my lord, in view thereof, my lord, and, my lord,
I've
this was.
understood. Yes, Mr. Basu. Yes.
So, these are my, and so far his judgments are concerned, my lord. 3 judgments my learned friend has shown.
Yes.
I just, my lord, just indicate, my lord, what are the differences. My lord, in all the judgments, my lord, which my learned friend has shown, my lord, lordship, the first is, my lord, Baban Rao. I just indicate Baban Rao, that's 2022 9 SCC 691. My lord, the clause is, my lord.
1 minute. Yes.
Baban Rao, my lord.
Yes.
The para 5 lordship will take that the clause is shall. The dispute shall be referred to arbitration. Of whom?
Yes.
The dispute shall be referred to arbitration of a sole arbitrator mutually appointed, failing which 2 arbitrators each to be appointed by one parties and 2 arbitrator to appoint a 3rd arbitrator, and the arbitrator shall be governed by the provisions of 1996 Act. That's clause 5. Then, my lord, that clause 5 mandate shall is there, my lord, and there's a dispute resolution by an arbitral tribunal, 1 arbitrator or 3 arbitrator. And Jagdish Chandra has been followed and approved. And, my lord, paragraph 21 and 23. Jagdish Chandra and KK Modi saying, my lord, to assume a mandatory nature of an arbitration clause, the word should be shall be, not may. And, my lord, the judgment further goes to say, my lord, that in case of considering as to whether the absence of the word final and binding clause would be considered in an arbitration clause, or final and binding is not necessary. What it should be shall be or shall. And if may is constituted to be shall, then the party autonomy is destroyed. This is the judgment. Now, my lord, the next judgment is power take, single bench of the Honorable Supreme Court. Of course, my lord, 2022 1 SCC 361. Clause is again paragraph 3, shall be settled through arbitration. My lord, there was 2 purchase order, one had shall, one had may. And, my lord,
Power
Supreme
take ki nahi okhane?
power take, my lord, 2012 1 SCC 361.
বলছে শুনতে পাচ্ছ না? Yes.
Para 3.
Yes.
Arbitration clause has a word shall. Shall be settled amicably or through arbitration. There was another purchase order which says will be settled by arbitration. That's paragraph 8. There were 2 purchase order in question.
No, paragraph 3, I don't, yes, shall be settled.
It shall be settled. Lordship can take it from here, or I correct it. There's another purchase order, that's clause 8, paragraph 8.
Yes.
Judge Sahib পেয়েছেন। Now, my lord, para 9 and 25, Lordship will find the clause Supreme Court holds, my lord, is ambiguous, little bit of vague, because either you can settle or you go to arbitration. But the ratio, my lord, boils down in paragraph 9 and 25, where, my lord, the opposite party, that is, my lord, the party who was opposing, my lord, did not dispute the arbitration clause, but said that you give me some other nominee. Here, my lord, I went forward and my lord opposed this section 9 saying there is no arbitration clause. And the finding is my assertion has been now, my lord, confirmed by the commercial court.
No, paragraph 25, what do you say, Mr.
My lord,
Ghosh?
paragraph 25, it records, my lord, the clause has not been disputed. Only thing is said that please keep it in abeyance, suggest some other name of arbitrator. Now, my lord, last is NRCon, which he has cited, 2014 5 SCC, page 1. Now, this is a case we all cite, my lord, for seat, venue, and
Yes,
distinction between the same and enforceability of an award under Part B, my lord. So, this, my lord, doesn't have any application here. We are in the first part. In this view thereof, my lord, there cannot be any arbitration. And this is the, my lord, of course, section 9, I'll be very candid. Section 9 court has held so, but that's prima facie. For the purpose of going into arbitration or not to arbitration or deciding it's an arbitration clause, stages are section 11, section 16, section 8, or my lord, section 32. So this is the final stage, has to be
Very
determined finally.
Mr. Basu? Yes.
Grateful. These are my respectful submission. Note to the I have prepared a 1-page bullet page, 3 pages bullet.
I will take it and when I need it. Yes. Yes, Mr.
My lord.
You can come back with the decisions if you want to distinguish them.
My lord, of course, my lord, and I would also say, my lord, that I have already cited 4 judgments, and so far as, my lord, may I just only indicate that I had not concluded my submissions. Anyway, lordship present, my
You
lord.
should have been here then. Or you should have prepared your junior so that your junior would at least start the submissions. Yes.
My lord,
Yes.
I kindly appreciate, my lord. I was running, my lord.
No, please. Don't
Anyway,
take all these.
my lord, so far
yes.
as only, my lord, for the time being, my lord, if may I indicate
Yes.
that my learned friend, my lord, says, my lord, that fairness of the petitioner to show and produce, my lord, section 9. My lord, may I say this list talk about the fairness of the respondent, that they have not shown the division bench order, which says, my lord,
Mr. Basu, I have
allow
not.
me to submit, my lord.
No. Sorry. I will discount what Mr. Ghosh has said about lack of fairness. So please skip that point.
Very well. I skip that point, but I will produce the order of the division bench, where the honorable division bench specifically said on their prayer that whatever the order passed in section 9, that is without, my lord, prejudice to the section 11 court. May I produce that order? Because
not important. I will only go on the construction of the clause. That is all.
But since, my lord, they have referred section 9 order, they should be prudent, my lord, also to refer the division bench order.
The construction of the clause, please.
Now, my lord, may I, my lord, if lordship permits, because they have cited, my lord, some 3-4 new judgments. So, in order to, my lord, for
new judgments, but that can always be cited by the respondent who is arguing for the first time. That is why the rejoinder of the petitioner. What do you mean by new judgments?
What I say, my lord, that so far as the 2 Bombay judgments, my lord, this was not placed before. So, if may
Very well, come back tomorrow. And 5 minutes to you, please. I don't like these kinds of emotional arguments in my court.
My lord, I am not making any emotional
Who
arguments.
is fair, who is not fair. Yes.
My lord permits him to, my lord, take this point fairness, and when I counter, my lordship, my lord says that I should not, my lord, respond to it.
Yes, Mr. Ghosh, show me the division bench judgment, please.
My lord, I have not even uttered. I only say, my lord, he uses this word fair.
Yes.
And when he uses this word fair, my lord, with all fairness. No, Mr. Ghosh, please. I have with all fairness, because I represent petitioner.
Yes, you have not.
You ought to have shown this judgment.
Yes, I showed what I said.
And with the deepest respect to my lord, I only indicate that since he has talked about the fairness, so I have every right to defend my client.
I have disclosed the order.
Mr. Basu, I have told you that I will discount what he has said.
My
about
lord,
fairness.
absolutely. My lord, the deepest of requirement, my lord says, my lord, that
yes, the court will only hear learned counsel appearing for the petitioner when counsel behaves properly in court. List this matter tomorrow. If you raise your voice, this is
My lord,
not
I
the
have
court.
not raised my
Try
voice.
it in
my lord.
other courts, not this
My
court.
lord, I have not raised my voice, my
Yes.
lord, with the deepest of
Next.
respect.
Very well. Next.
My lord, kindly, my lord, but do not keep it tomorrow, my lord. Kindly do not keep it tomorrow.
Tomorrow. Next. Prepare your junior. Next. You should have argued today.
Five,
Next.
Rajiv
My lord, I am ready to argue the matter today even.
Today? Yes, yes. Argue it. Lower your voice immediately.
My lord, I have not raised my voice, my lord. This is
Lower
my-
your voice immediately. No further arguments with the court. Make your submissions.
কি করবো বল? নাকি তুই অন্য কাউকে বলবি?
Come on, you said you're prepared to argue today.
I am
Argue.
prepared to argue, but
Yes, yes.
so far as possibly, my lord, I am not minded to argue because,
Very well. Yes, argue. Make your arguments, please. I was supposed to keep it tomorrow. Yes, argue.
my lord, kindly keep it tomorrow, my lord. I will request my advocate on record. my
Very
lord.
well. যে অর্ডারটা বলেছিলাম সেটাই থাকবে. Yes, next.
And my lord, kindly record, my lord, it is not my case that I am not ready. Kindly also record.
Next.
Great.
Because lordship has recorded that I am not ready.
Very well. On counsel further says that counsel was willing to argue today, but when that opportunity was given to counsel, counsel again says that he will argue the matter on some other day. That he is not in a mental frame of mind to argue the matter today. Next.
Great. Much.
Next.
Item number 5. Item number 5, Rajiv Tibrawal.
My lord, on the last day, my lord, pursuant to my lord's order, I have filed a supplementary affidavit. My lord, yesterday, my lord, lordship, my lord, did not record. My lord, may that be recorded. We have also, my lord, given them a notice, my lord, with a copy. And in compliance, my lord's previous order. This is my duty to indicate to your lord.
Make your arguments. Yes. Next matter.
Lordship, I appear on behalf of the petitioner. This is my Section 11 application. Your Lordship, may I file my affidavit of service?
Yes.
Lordship, the dispute, I am one of the partners of a limited liability
This is Section
partnership.
11.
Yes, Your Lordship, Section 11. So I'm one of the partners of a limited liability partnership firm. Lordship will find the agreement of the limited liability partnership at page 11.
Give me the date, please.
Lordship, 7th of December 2012. And Your Lordship will find the arbitration clause at page 21.
7 December 2012.
Yes, Your Lordship, 2012.
Arbitration clause.
Your Lordship, arbitration clause is at page 21, clause 38. May I only place the arbitration clause that any
Mr. Kothari, microphone, please.
Your Lordship, clause 38 is the arbitration clause. May I just place the arbitration clause that any disputes or differences arising between the parties hereto as to the effect, interpretation, or application of this agreement as to their rights, duties, or liabilities thereunder.
One
Or-
minute. Mr. Mitra, are you opposing?
My lord, I appear for 3 out of the 4 respondents, including the LLP. Now, my lord, the only issue is one of the partners of the LLP, who was impleaded as R2, has now tendered his intention to resign or retire from the partnership. Otherwise, I don't have any problem, my lord, if an arbitrator is appointed. I appear for R1, 3, and 4. My lord, there are allegations made against us. Those allegations should be deemed to have been
R1,
denied.
3, and 4. And you are for 2.
Well, lord, I am for 2, and well, lord,
Yes.
greatest of respect to my learned friend, my lords, perhaps 1 anymore, because my lord, I'll tell you, lords, 4 partners in the firm. My lords, Mr. Kothari's clients, my lords, is one of the partners. My lords, my clients has been one of the partners, and the remaining 2. So there is absolute deadlock. Now, my lords, the reference, my lords, the Section 21 notice, if your lords have a look at, my lord, my learned friend's clients, the petitioners, my lords, say that, my lord, there is absolute distrust between the partners, and he's been excluded from the partnership. I have been also been saying same. My lords, there is a matter, my lords, there's been a suit that has been filed against me as well. I have tendered my resignation, and I have, my lords, withdrawn all my consent, wakalatnamas, authorizations given to my lords, for to represent my lords R1, my lords, which is my lords, the partnership firm, or the LLP, for that matter of fact. My lords, I have just only
So
one
you're
submission
saying
to
that
make.
Mr. Mitra can't represent R1?
R1, no, my lord. He can represent, my lords, R3 and R4, because, my lords, if there's a specific clause, my lords, if your lordships kindly have a look at the agreement, my lord, if your lordships kindly have a look at, my lords, page 20 of, my lords, the petition,
Yes.
the decisions, my lords, clause 20, my lords, if your lordships have a look at, my lords, clause 29, my lords, at page 20.
Yes.
Lord, if your lordships have a look at that, my lord, the decisions, the matter discussed in LLP shall be decided by resolution passed by a majority in the number of partners, and for this part, each partner shall have one vote. So, my lord, there is clearly not majority, my lords, because if four, my lords, two, my lords, two on one side, two on the other side. My lord, I'm not supporting the petitioner, but my lord, my only submission is this: since I have retired, my lord, I've given my notice, and my lord, ultimately, my lords, I am entitled to 1/4 of the shares. Now, my lord, the reference, my lord, what matters is what is being referred to arbitration. If it is, my lord, the dissolution, or for that matter of fact, my lord, the partners, my lord, retiring with their respective shares to be decided, then the question, my lord, it becomes, my lord, I am not opposed to arbitration. We do not want multiple arbitration proceedings. If it can be, Malaj, resolved, Malaj, in a common arbitration proceedings, Malaj, this particular issue, Malaj, it will be grateful to you. Because Malaj, ultimately, I tell you, Lords, I've given my notice.
No, there will obviously be no multiple arbitration. There will be just one
That's right,
arbitration.
Malaj. So, Malaj, no, Malaj, the issue is this, Malaj. I'll tell you, Lords, the issue is this. Now that I have resigned and there is no majority, Mr. Kothari's clients would be, Malaj, the claimants. I'll be the respondent. My counterclaim will not effectively be against, Malaj, the claimant herein, but Malaj, the LLP. So, Malaj, I was hoping, Malaj, and I spoke to Mr. Kothari about it.
Mr. Banerjee, entirely a matter for the arbitrator. You make your counterclaim, whatever form.
No, Malaj, I'm so grateful, Malaj. The reference should not be restricted to, Malaj, that only, Malaj, his claim as regarding, Malaj, a certain sum of money. If that is so, Malaj, with greatest of respect, Malaj, and now Praveen Enterprises, Malaj, has also answered that question.
No, Mr. Banerjee, no. You raise these points before the arbitrator.
They're all matters before the arbitrator.
Yes.
But
And yes, what is this about, Mr.
No,
Mithra? Yes,
I'm
that
representing R1. I'll also file, my lord. My vakalatnama is not on record. I've spoken to my advocate on record. He says he, due to some personal difficulty, can file it only tomorrow. But be that as it may, that is also not an issue that should detain your ladyship for that purpose. My lord, we don't have any objection per se. If, my lord, an arbitrator, and your ladyship may recall, sitting in another jurisdiction, your ladyship had passed the order on Mr. Kothari's application. There was a writ petition.
yes.
No,
I don't remember.
That order is annexed.
Yes.
Ladyship had given 8 weeks time for them to seek relief elsewhere for debitories.
Very well. So you don't have a problem with appointing an
Arbitrator can be appointed, and since there are allegations leveled against us, I'm not using an affidavit. Those should not be deemed.
Yes.
Malaj, same here, Malaj. Just Malaj, kindly record my submission that Malaj, in light of Malaj, the clause in the agreement in question, Malaj, perhaps my friend cannot represent R1. Malaj, R3 and R4, of course, in their individual capacity.
Very well. I will of course record what you're saying.
Malaj, represented. And Malaj, that only thing is that the reason I wanted to say is even I am not opposed to that, but the reason is Malaj, the assets of Malaj, the part of not going into the merits in its entirety, Malaj, it's 55 crore. If it has to be divided, Malaj, if it has to be a claim, accordingly an arbitrator has to be appointed. Malaj, that is my only submissions, Malaj. Because
so that is
not
what the
only the claim of
yes. Mr. Kothari, what is the dispute?
Lordship, if your lordship observe that all disputes are referred to arbitration, I think my learned friends.
Naturally, yes. What is the dispute?
Lordship, my reference was limited to the fact that my capital account was wrongfully debited, and thereafter they had withdrawn 1.7 crores from the bank account, and that's what I've referred to the arbitration. But my learned friend say, Mr. Banerjee is saying that he wants to. Perhaps he wants a dissolution as well. So if your lordship observes that all disputes are referred to arbitration, that will take care.
Yes. So the dispute is that 1.7 crores was debited from your bank account.
From the bank account of the partnership firm
without your knowledge.
Without my consent, and my capital account was wrongfully debited.
Malad, if you, I'm sorry, Malad, to intervene. Page 6.
1 minute.
I'm sorry.
So this 1.7 is also the capital account point.
Lordship, these are two separate points, I must say.
So your capital account was debited as well?
Yes, your lordship.
And what is this 55 crores now?
Malad, if your lordship kindly comes to Malad, page 60 of...
Mr. Banerjee, I'm not talking to you.
I'm so sorry.
Yes, what is this 55 crores now?
55 crores is probably the whole assets of the partnership firm which Mr. Banerjee is referring to since he's seeking a dissolution.
Very well. Anything else, Mr. Kothari?
No, your lordship.
Yes.
Malad, if your lordship, I'm sorry, Malad, for
that's all right.
Page 60 of the petition, Malad. Now that's his Malad's section 21 notice, Malad. And that's his case, Malad, para 2, Malad. Since March 2020, Malad, first, Malad, my client undisputedly holds 25%, 1/4 of the share in the addressee 1 LLP.
Well, since March 2020, the affair of the respondent, aforesaid LLP,
No,
the addressing.
what is page 60?
Well, I just section 21 notice.
Say
Right.
that, please. You can't just take out the page and
No,
then
I'm sorry,
start
perhaps,
quoting. Yes.
perhaps I said, but 59 is the first page of the
Yes.
section 21 notice.
Yes.
It's dated 18th of August 2023, Malad. And if your
Yes.
lordship comes to page 60 now, which is para 2, since March 2023, the affairs of the aforesaid LLP, the addressee number 1, are being conducted by the addressee number 1, 2, and 3 to the exclusion of my client. Money from the account of the addressee number 1 have been siphoned away in the personal accounts of the addressee number 2, 3, 4. The addressee number 2, 3, 4 are unilaterally taking decisions to fasten liability to the account of my client. And then he, Malaj, goes on to say, Malaj, next page is the injunction. And 62 is that since disputes and differences are arisen between the parties, page 62, Malaj, para 6,
Yes.
hereby invokes the arbitration clause, so and so. So, Malaj, of course, Malaj, he himself says that even his clients have been excluded. That's the difference. Well, I am saying that I've been excluded, matters being filed against me. There's an absolute distrust. There is no clear majority Malaj in the LLP.
Very well. Yes. The disputes between the parties arises out of a partnership, of an LLP agreement, LLP agreement dated 7th December 2012. Stop. The petitioner and the 3 respondents are partners of the LLP and claim to be equal shareholders. Is that correct or not? Claim to be equal shareholders as well, of the LLP as well. Stop. Equal partners of the LLP as well. Next, the dispute arises out of, the petitioner is aggrieved of certain acts of the respondents, namely of withdrawing rupees 1.7 crores from the partnership account, as well as certain other monies from the petitioner's capital account. Stop. Next, the learned counsel appearing for the respondent number 2 takes 2 points, comma, however, not with regard to the maintainability of the present application. Stop. According to counsel, comma, the respondent number 2 has also resigned from the LLP and now seeks to dissolve the same. Stop. Counsel also submits that the respondent number 1 cannot be represented by Mr. Mitro, Mr. S. Mitro, since by reason of clause, which clause is that?
It's clause 29 of the agreement.
Clause 29 of the LLP agreement. Stop. Next, the respondent number 1 has not filed his its wakalatnama as yet. Stop.
But even I have not followed today's comment.
None of the respondents have filed their wakalatnamas till date, even though the application was filed on 22nd December 2023. Stop. I can't then hear any of you. Mr. Banerjee, you're making so many submissions.
I understand. I should have pointed this out. Apologies,
yes,
for this. But I undertake
yes,
to do that.
After making his submissions on behalf of respondent number 2, comma, Mr. Banerjee points out that he also that the respondent number 2 has also not filed its his wakalatnama. Stop. Next. None of the respondents hence have a right of audience, and the recordings made above may be ignored for the time being. Stop. Next. List this matter tomorrow on the undertaking of the respondents to file their wakalatnamas by 4:30 p.m. today.
I'm so grateful. I'm so grateful.
I make one prayer. I had taken instructions on this. By 4:30 p.m. may be difficult. My advocate on record isn't some difficult.
What have you been doing since 22nd December?
That's why I started with that submission. May it be on any other day in that case, because
we only have only on then Monday. After tomorrow, it's Monday.
Wednesday.
would
I
Tuesday
can't understand what you're
would
saying.
Tuesday or Wednesday comment instead of Monday?
Why? Where are you based?
Wait, Monday I'm not in Kolkata. Monday is the one day I'm not in
Can I make
Kolkata.
the same prayer, Mulaj, Wednesday, Mulaj, if it's possible? I'm sorry, Mulaj. I should have indicated this in
Yes,
the
council now seek to file their wakalatnamas according to their individual
No, Mulaj,
convenience.
we want to do it by 4:30 today. I am fine with tomorrow, Mulaj. I am fine with tomorrow, Mulaj. I can file it, Mulaj.
It's your leadership direction.
I can.
Mr. Mitro, hardly matters whether you're in court. Your client has to file the wakalatnama.
No,
That's all.
Monday's difficulties, mine 4:30's difficulties, my advocate on records, I'm told. But if it's your direction, I'll convey it to him. He must comply there. If it's your leadership,
It's a direction.
very well.
Nothing to do with convenience of
Kindly
council.
keep it for
Yes,
today.
by 4:30 p.m. today.
Very
Stop.
Great.
List this matter tomorrow. Next.
Great.
No.
Item number 6, National Insurance Company Limited versus Tirupati Food Products.
34.
Yes, Your Lordship.
Yes.
Mr. Banerjee, you were arguing the matter.
Yes, Lordship. Lordship, I was arguing that matter. My only point of argument is
Microphone, please.
my
Yes.
only point of argument is the deficiency of reasoning in the award, Lordship. I would make my submission.
Deficiency of reasoning means that there are
No
some reasons, but that the reasons are insufficient.
No, Lordship. There is no.
Are you saying that, or are you saying there are no reasons?
I'm saying no reasons. I will be relying on Lordship Somdat Builders, Taya Technologies, and then Palm Developers, which is passed by your Lordship. And there is a
It's
Rohan.
not Palm, it's PAM.
Yes, Lordship.
PM.
I'm sorry.
Yes.
Rohan Real Estate Private Limited, Bombay. This all three judgments
On what point?
only on the point of
No reasons.
no reasons. Lordship.
Why do you need judgments for that?
I'm just ready. Otherwise,
It's now part of the Act.
Yes.
31(3).
Lordship. Now, Lordship, I would take your Lordship to the award first.
Just don't place the entire award. Just show me that it doesn't have reasons. That part.
Lordship. If your Lordship kindly turn to page 100 and page 204. Item wise,
204.
yes, and then 206, few pages, just the heading,
Yes,
Lordship,
yes,
I will show.
yes. What is this at the top?
Price.
Item wise, what is this?
We have taken some points that
You were the claimant.
no, I am the respondent.
Respondent.
Yes, I was the respondent there. The entire thing is due precaution and care was not taken by the insurer holder, and he suffered a loss. I cross-examined the proprietor of the claimant or the authorized officer of the claimant that what are the steps you have taken. He said, I have taken no steps. He admitted that. And he had a previous experience of same incident at the same godown under the same policy. Then I said that you knew that water logging could be here. What are the steps you have taken? He said, I could not take any steps. I have only lay a polythene sheet, and above that, perishable food grain I have stored. Then in this time, Anfan, he had a 7 days notice because meteorology department announced that is going to happen. So I said, did you try to shift your material to other godown? Because he has other godown near in Calcutta. He said, no, I have not taken steps. So reasonable due and care was the point I argued. I cross-examined. I argued. Court has recorded that. And now, Lordship, I am taking your Lordship to the point-wise discussion the arbitral tribunal has gone in. Lordship,
No, just show me the paragraphs according to you which should have contained reasons but do not, according to you.
Lordship, then 221. Lordship, I'm sorry, 210. Lordship, kindly come to first 210.
Yes.
First, after discussing the argument and the evidence, the distinguishing case. The claimant did not cite any decision. The respondent relied upon 12 decision. However, at the time of argument, they rely on 2 decision. AIR 1983, such and such, Supreme Court, a case of such and such, new insurer assurance.
No, that's what you don't have to mention the decisions which they cited. Just
Lordship,
show me
that's,
that no
that's what I'm
reasons.
saying. Now,
Yes.
Lordship, kindly turn to next page. My cases, facts were not dealt, Lordship. Then my cases are not dealt.
Yes.
Then page 211.
Yes.
The other case relied upon by Mr. Banerjee would relate to a distinction between flood water, rainwater that would overflow into the water body. In instant case, there is no water body involved. The said case would have not. Then, Lordship, the view of the tribunal, my view.
Yes.
The reason for the
Mr.
denial of
Banerjee's
the
view.
yes,
Yes.
I take this. My view is the reasoning part starts.
Yes.
The reasons for denial of the insurance claim in the case in hand has been advanced by the insurance through the evidence laid down by the insurance, followed by the eloquent argument advanced by the learned counsel on behalf of the insurance. Unfortunately for the insurance, none would inspire my confidence. I pause here for a moment. Lordship, no reasons given. I have
No,
already
none
held,
would inspire my confidence means what?
uh,
That's the reason. None would inspire my confidence means what?
Lordship, maybe.
No, I'm asking you.
Lordship, in the plain reading, it seems that the argument of the council have not convinced him. That's what he
It was
wanted.
bunkum.
I-
None would inspire my confidence. Yes. And then the pricking of conscience follows. This is that award.
Yes.
Yes.
As stated above, since allowance in the rule of insurance company would have been approached the problem with strict proof much higher degree than has not happened in the instant case. Lordship, this is the theory based on which the award is passed. Means allowance is the general principle, non-allowance has to be a stricter proof. This is where the tribunal express his mind for formulating the reasons given or not, that's a different issue. This is where the tribunal has expressed the mind. That when I say,
Very well, I've understood. Surveyor is your surveyor.
Lordship, this is also generally said surveyor is insurance company surveyor, not no. Under IRDA rule, they are the independent member empaneled with them. We call them. Surveyor was absolutely different than of the insurer company. And that
Yes.
is the reason why under IRDA rules, surveyor reports I cannot ignore. But if there is a huge lack or difference, I can refer it to the next surveyor.
Yes. Very
The
well.
surveyor did
Yes,
the
yes,
survey.
I've read it, Mr. Banerjee. Yes.
Then Lordship, I'm not reading that portion. Then yet my conscience speaks. My conscience would speak on one issue. Did the insurer acted upon the 4 days caution notice issued by the government authority that the Amphan will be coming? The claimant could contain he did not have sufficient time to shift the material. He might be correct. However, I feel an honest and sincere attempt should have been there. The claimant did not venture for the same. So, Lordship, if the tribunal was convinced to the extent that he could have done it and he could have avoided the loss, and then Lordship awarding that is the conflict of mind itself. First, the court said that stricter proof. Then he said that no, there was. So, court has admitted this fact. Tribunal has admitted this fact that he could have. Then he said, I could not do.
Yes, but then the conclusion is I feel some amount of claim to a reasonable percentage should be disallowed. That is the fallout of the pricking of conscience.
That even barely 8% he has deducted, which is policy term under the policy itself.
Yes, so how much has he deducted, Mr. Banerjee? What was the claim and how much?
8% he deducted, which is the policy term itself.
No, what was the claim and how much did he deduct?
Claim was of the 4 crore.
Yes.
he received 2 crore from us, from the salvage, because we took over the entire thing. We
Yes.
sold it out under our this thing, and then we paid the salvage money to them.
Mr. Banerjee, just look at that line and tell me how much he deducted. That's all.
Lordship,
I feel some amount of claim to a reasonable percentage should be disallowed. How much is it disallowed?
10%, Lordship, result.
10%.
Result.
Yes. So 10% of the claim he has disallowed.
10% of the claim. Under the second policy claim, I am actually entitled to deduct 8% of that. But
Very good.
Lordship,
Next.
now Lordship, Mr. Banerjee appearing for the insurer has made strenuous submission that despite...
I've read all that, Mr. Banerjee. I've read all that. That's why I've gone to the next page.
Oh, then Lordship, before I part with.
Yes.
So that is again the not reason. I mean, it's just a thank-giving part. Conducted in a 4 slot. Lordship, this is the arbitration was conducted in 4 slot each, one each in December, January, February, and March. There was altogether 20 number.
Where are you reading from?
214. Lordship.
Yes.
Before I part with.
Yes.
The reference was made to this April such and such. I entered upon such and such. Although belatedly, I held second sitting in such and such to decide upon the venue and this. Then Lordship Training Institute. Then arbitration was conducted in December, January, February, March. We altogether 20 sittings, parties agreed. So this is, I cannot take it as a reason. So Lordship, then he could not lift, one reason. He did not take precaution and caution of the goods. Second reason. Third, the deduction he received.
Banerjee, the reasons come only from page 211, or is there some other reason somewhere?
Lordship, to my understanding, if your Lordship now, item wise, if I now read page 185 and onward, if your Lordship, that's what I was trying to show.
Yes.
Now, page 185. This is the first item on which first he analyzed the case of both the parties. Now, scope of the reference. I argued on the scope of the reference.
Yes.
Mr. Such and such learned counsel appearing for the respondent insurance company would draw attention of this learned tribunal to the notice received such and such, appearing such and such page before the Honorable High Court under section.
Let me read it, please. What is all these headings? What are all these headings? Price drop, dust particle. What is all this?
These are the defense, Lordship, I have taken.
Defense.
Yes, Lord.
Your defense.
Yes.
Very good.
No, my defense. He stated the Clement case. That's at page.
Mr. Banerjee, answer the court's question. What are these subheadings?
Defense.
Defense. Very well. Yes.
First, he summarized the case of the claimant. If your Lordship kindly see that. Case of the claimant has been.
And what is reasonable care? That was your argument?
Yes, Lordship. That is tenuously I am arguing before your Lordship as.
Yes.
Scope of the resident, dust particle, seepage condition, and the reasonable care. Now, Lordship, kindly see. The survey report shows 15% deduction on the poor condition, such and such. Mr. Banerjee would contain this too would conclusively suggest there had been a deficiency in reasonable care on the part of the claimant. The claimant has rightly reduced the surveyor on that count. According to Mr. Banerjee, the insurer is neglecting in discharging his duty under the contract of insurance. He would not be entitled to claim.
So these are all your submissions?
Yes.
All these headings form your submission?
Yes, Lord.
Not the arbitrator's view?
No, Lord. So, Lordship, this reasonable care, I have argued and I have shown that cross-examination. I have
Santosh Shaw,
my other witness.
your other witness.
My second witness. I have given 2 witnesses. One is the surveyor, other one is the officer of my client. Now, Lordship, like this way it will go. If your Lordship takes the last, then 197, Lordship, if your Lordship kindly come. Mr.
Very well. So the arbitrator goes on 199. I'm on 199. Relies on the survey report of the surveyor, saying that there was a genuineness in the claim. Come to 199.
Analysis of the.
Yes.
Lordship,
That's the arbitrator's view.
That's. there are two parts. One part is claim deducted or reduced to some extent. It has been reduced to 50%. So that reduction was right or wrong is one part of the logic. Second part is whether at all he is entitled to anything because he has not taken reasonable due and care. There are two parts of it. So, Lordship, my part, reasonable due and care, has not been dealt with, Lordship, I have shown. And then, Lordship, kindly see even the analysis. May I place that analysis? If we analyze the survey report, we would find a complete consideration of the
Mr.
entire...
Banerjee, I've read all that. Come to page 201, please.
Lordship.
All this salvage, dust particle, what is all this?
These are all defense because there was a
Your
salvage.
defense.
Salvage is already given to it, sold and given to it. And this was also reflected in the insurance report that this much of material become dust particle, this much of material become unfit for human consumption, this much of particle become salvage and salvage is sold. And that money has been given to it. So, Lordship, even in that's why I was trying to show. Even when the tribunal was taken an analytic view of that document also. There also court has not given any view that this can be accepted, cannot be accepted. If not, this is the reason why cannot be accepted.
What about page 203, last paragraph?
Lordship. The goods were, I'm reading the last paragraph.
I've read it. I'm asking you.
Lordship,
What do you have to say?
this is also not a reasoning matter. The goods were stacked in a gunny bag. The upper layer was affected by the rainy water. The shade was broken off. The lower layer was affected by the rain, came inside the go down from both top and vein. However, the mid level was least affected. Surveyor collected the sample as well as the worst sample, got them tested. The relevant extract of the laboratory report appearing in this is reproduced here. Lordship, that is also the recording. It's quite correct. Yes, I am saying that water logging. So the from the bottom it will be affected. There was
and the fact that you accepted the surveyor's report.
Lordship.
Next
Lordship.
page.
The surveyor was satisfied with the report that would be apparent from this act. He did not go for the further analysis by any expert. I cannot go. Under RDI, he cannot go, Lordship. The insurance company also accepted the surveyor's report in toto. That would include the analysis report. Now, Lordship, what I am saying is pausing here for a moment. If my surveyor report need to be challenged, either the tribunal has to expert witness to understand whether that was correct or not, or the claimant would have given an expert witness to prove his case. Now, Lordship, the expert evidence has been ignored and said this is right and this is wrong on the basis of the wisdom of the tribunal, Lordship. And then also that wisdom is not reflected in the reasoning.
Very well. Wisdom is not required anyway. Yes,
reasoning.
Come to page 206. What is this price drop?
Price drop is again another defense that during that time, the price of the material dropped, Lordship, because consumption was less and I have produced the survey report.
Who is Mr. Chatterjee?
Mr. Chatterjee is Mr. Amit Chatterjee, who was appearing counsel for the claimant. And another Chatterjee was there, Shorin Chatterjee was there, who was the surveyor.
No, says I have analyzed the evidence of Mr. Chatterjee, the surveyor. So can't be.
Then the surveyor Chatterjee.
Yeah.
He was the witness. Witness number one. Defense witness number one. Lordship.
Yes, Mr. Banerjee, I've read the award.
Lordship.
Yes, what do you have to say?
Lordship, this award.
5 minutes.
Lordship.
Yes.
This award is passed that entitlement of the claimant. I said he is not entitled because he has not taken due care and reasonable care of the goods. That point has not been dealt by the tribunal, even not spend a single sentence for reasoning of that no, he could not have taken care or the situation such. Neither evidence given by them, nor argument made by the claimant, nor the tribunal has given a reasons for that. Second, my surveyor's report is being placed. My surveyor has given a full my all documents, including the videograph document, admitted by the claimant's witness there. Analysis is made on based of that surveyor's report, but the surveyor's report could have not been faulted in absence of a contrary scientific report. There was no report. Either the tribunal
No, the
suggested.
tribunal notes that you have accepted the report.
I have accepted. Now, if the report goes, then they are not entitled. If it is as per the surveyor's report, surveyor made that deduction, Lordship. That has been recorded.
Now, Mr. Banerjee, I've read the award, please. Now, don't go back to the award. Yes.
Lordship.
Yes.
So the surveyor recorded. I paid as per surveyor's report.
Yes.
This is nobody's case that I have not paid in terms of the surveyor's report.
Yes.
Whatever the deduction surveyor has made, Lordship has seen that dust particles, salvages, these are all heads under which the deduction is made by the surveyor. So I liked or disliked. I disliked actually because I was paying the second time insurance claim on the same policy. But still under RDI, I am bound by the report. I cannot go away. So I accepted the report and the salvage amount of 2 crore, 1 crore 90 something, I paid him. Now the rest he is entitled to or not. There the surveyor said, no, salvage, yes, you are entitled, this you are not. So I accepted, I acted. So this is not the case where tribunal is passing order.
That is all, Mr. Banerjee, your 5 minutes are over. Anything else?
No. So one line.
Yes.
This is not a award to say that admission on based of the surveyor's report. This is an award where dehosts the surveyor's report, the award is passed. So since it is not considering and considering it to be not correct, so as to be a reasons proper to that extent or a contrary evidence to that extent by a which is not there in the matter. That's all.
Thank you. Mr. Kothari, you will come back when?
Any day.
Yes. You will have a chance to rejoin, Mr. Banerjee, after hearing Mr. Kothari. Learned counsel appearing for the petitioner award debtor has made his submissions on essentially the absence of reasons in the award. Stop. According to counsel, the arbitrator, the learned arbitrator, has failed to consider the submissions made on behalf of the petitioner, within brackets, respondent in the arbitration, close brackets, NIC, National Insurance Company, on primarily the lack of duty of care on the part of the respondent, within brackets, respondent, who was the claimant. Stop. Next, list this matter. Next week, Mr. Kothari. List this matter on 15th January 2024.
Grateful.
I'm obliged.
Next.
Item number 7, Cholamandalam Investment versus Uma Earth Movers.
That I am to reply to Mr. Banerjee's contention.
You had taken a.
I had taken the point of maintainability to his section 9 application on 3 counts.
Yes,
Addressed your lordship on that.
Yes.
I am just going to reply on that, my lord. I was there virtually the other day. Your lordship was kind enough to keep it today.
42, 23, and no arbitration clause.
42, 23 and jurisdiction based on 3. Essentially, my lord, what he's argued is something that he's argued reading up and not based on what he's pleaded. He's argued primarily 2 things. Sorry. One is section 42 bar will not apply because the section 9 court, city civil court, had no jurisdiction.
Yes.
Because it has no jurisdiction, order 23 will not apply. I don't know how he's come to this because he's not shown any judgment or the law on this, but this is what he's argued. And the next is on facts about how everything was done here, and jurisdiction. There is a clause that wherever they want to go, they can go, and therefore they've come here.
There's an
Essentially that.
Or something.
Or with regard to the claims and all that. 2 important things he's argued, Manoj. One is because of section 21E, and which is the principal civil court, city civil court has no jurisdiction at all to decide any section 9 application any further. So this is his argument. The ramification of that is, if this point is agreed, city civil court, no section 9 will lie. He's relied on 2 judgments. I shall show that a law has not been accepted to be the same once the Commercial Courts Act have come in, and there's a notification that mentions that 0 to 10 is city civil court, 10 to 1 crore is concurrent, 1 crore above city civil court is out. Now, to obviate this difficulty, he's gone ahead and argued that pecuniary jurisdiction is not something you can ascertain in a section 9 state because it's an application. But if that be the case, in my understanding of that argument, this actually is counterproductive. Because then it either is only city civil court because it's 0 to 10, or it's at least concurrent.
I just interrupt here. I have not argued that. I have said that there is no financial platform under the Arbitration Act. That is what I have argued.
Yes.
Not for
So
section.
pecuniary jurisdiction is not something that the court can look at now. If I have to bring it down one legal term, then there is no question of pecuniary jurisdiction today. So if that be the case, and I'll repeat myself, 0 to 10 will be city civil court, 10 to 1 crore will be concurrent. Now, all judgments that he's referred to are pre-Commercial Courts Act, or none of them consider the Commercial Courts Act. This issue had come up before your lordship, where this notification was shown with regard to the Commercial Courts Act and 21E and the concurrent jurisdiction with regard to the pecuniary value. A section 34 application was filed here. A section 9 had been filed in the city civil court. The respondent opposing the section 34 application had said, taken the point of section 42. This argument was advanced that section 9 court was there without jurisdiction, and therefore this 42 will not apply. This court considers the entire gamut. The judgments which I forwarded that decision passed by your lordship to Mr. Banerjee the last day, the entire gamut of the law existing pre-Commercial Courts Act, the effect of the notification, and comes to a conclusion, and in my understanding rightly so, that if there is a concurrent jurisdiction by a notification that's come out pursuant to the Commercial Courts Act, this concept of 21E will not apply, because then you're taking away the entire basis of calling it a concurrent court. There is no question of one being a principal civil court if 2 courts parallelly have jurisdiction in respect of the same matter. So the effective word here will not be civil court, it will be the principal. So the principal civil court, yes, Mr. Banerjee could have argued, and when he was argued, in fact, and I'll be honest, I wanted to concede on this point. Because to me, when you
point that
to this point of 42, I actually wanted to concede on the point, because it appeared what he was arguing was the right law, and I didn't want to come and argue something to make a hash of it. Then this judgment came to light. And it considers the most important aspect of the effect of 2 courts having concurrent jurisdiction. Then which court becomes principal becomes redundant. And I'll place that judgment. But before that, your lordship will test if this argument at all gets validated by his pleadings. Because the pleading is that we filed the section 9, got an order for a receiver, withdrew it because there were some technical defects. Cut to my point 2 now. This aspect of city civil court having no jurisdiction at all was not a ground that was made there. Of course, point of jurisdiction does not have to be pleaded. But if I look at it from the angle of Order 23, then he does not withdraw it on the ground that you don't have jurisdiction. His application for withdrawal says there are some technical errors, therefore I'm going to withdraw. And candid enough, he's agreed that there is no liberty. So factually, his Order 23 point does not hinge on this aspect of jurisdiction. Even if I'm to give him the credit for that, he will have to show that a court that does not have jurisdiction, if I have gone there and I have withdrawn that matter, leave under Order 23 is given a go by. I have not found a judgment like that. I don't think even he has, because he's not cited anything. Milord, this really, I'm sorry, Milord, this really somewhere impacts the purpose of Order 23. Because this is not a situation, now academically I'm saying, because this is not.
So you're saying that, sorry, Mr.
Yes,
Banerjee, please continue. So you're saying that Order 23 is indifferent to whether a court has jurisdiction or not?
Yes. If I have withdrawn it.
Yes.
Look, two aspects can be there. One is when I have filed an application, the court has passed an order. The court is without jurisdiction. Then 23 doesn't apply. I can come and take the point of jurisdiction nullity. Law protects me. The other is that is pending. I come here and say I'm going to withdraw it. With an undertaking, I file the second one. With the undertaking, I'll withdraw the first. 23 doesn't apply. The other is it's pending. I have come up here and I'm showing what is pending is quorum non judice. Even if it's pending, it doesn't matter. That also the law allows. These three aspects, the law gives them that liberty. All 323 does not apply and there are judgments on this. But I have not found a situation where you go under before a court, withdraw it, don't get that liberty, file another proceeding in a different court, and then say that court was the jurisdiction, Order 23 will not apply.
How is this situation different from the first example which you gave, Mr. Banerjee?
My lord, in the first one, there is no withdrawal. If there is no withdrawal, the Order 23 is no application. I can come to a court and challenge an order on the ground of it being without jurisdiction. The court can disregard an order on the ground of being without jurisdiction. But in situations where these are all situations where the courts have held, and your lordships have consistently returned a finding that Order 23 has no application. But where Order 23 applies, so Mr. Banerjee to cross that threshold would have had to show that where the court is without jurisdiction and have gone ahead and applied with the liberty to file afresh and it's not been given to me. I'm assuming that was there in the application. Then Order 23 Rule 1 bar will not apply to me. I have not found that judgment and he's not cited anything. So at least the decision that I have cited is on the point that Order 23 principle is founded on public policy. Courts must ensure that this is followed to stop or thwart frivolous litigators or litigations from approaching different forums, from bench hunting. And he was honest enough to come and say that we've not been given that liberty because the order is on record. Now, the more important and more fundamental question, my lord, with my understanding with a massive ramification, that no Section 9 application henceforth, if this judgment is passed, City Civil Court will entertain. City Court stands denuded of its jurisdiction to entertain any Section 9 application. Because this is the principal civil court. Well, I'm consciously not using the word hierarchy. Yes. I understand your lordship's reservation on that. This is the principal civil court and that is not. Well, this in the context of the notification and the Commercial Courts Act, your lordship will kindly have a look at this judgment. This is reported in 2023 SCC Online Calcutta 2271. Thank you.
Yes.
No, your lordship will allow me to place this. This is important. The petitioner award debtor has filed the present application under Section 34, paragraph 2. The respondent award holder has taken a preliminary point of maintainability of the present application on Section 21E and 42 of the Act of 96. The respondent says that the present application should be filed before the City Civil Court since the petitioner has already filed a miscellaneous application in that court. Learned Counsel appearing for the respondent also takes the point of pecuniary jurisdiction of the High Court and City Civil Court as determined by a notification dated 20th March 2020 issued by Judicial Department of the Government of West Bengal. The brief facts disregard it, not important. 5. Section 21E of the Act May I, my lord, paragraph 5.
Yes, yes.
21E of the Act defines court for the purpose of domestic arbitration as the principal civil court of original jurisdiction in a district and includes the High Court in exercise of its ordinary original civil jurisdiction, having jurisdiction to decide the questions forming the subject matter of the arbitration if the same had been a subject matter of a suit, but does not include any civil court of a grade inferior to such principal court, civil court, or any court of small causes. Section 42 begins with a non-obstante clause and stipulates that any application within respect of to an arbitration agreement under Part 1 of the 96 Act would confer the court alone with jurisdiction over arbitral proceeding, and all subsequent applications arising out of that agreement and the arbitration proceedings shall be made in that court and in no other court. The object of Section 42 is to prevent conflict and multiplicity of decisions of different courts. The section aims to provide uniformity by bringing the parties to the court where the first application was made under an arbitration agreement and ensuring that all subsequent applications are made only in that court. The undisputed facts indicate that the petitioner approached the learned city civil court in this case filed by the respondent and prayed for appropriate orders with regard to release of the petitioner's vehicle. The petitioner has also made specific averments in the application stating that the civil court is empowered to forthwith try and entertain the application and pass necessary orders. The petitioner at such point of time did not take any stand, this is important, Lord, did not take any stand of the civil court not being competent or empowered to try and entertain the arbitration. Learned counsel for the petitioners relied on a division bench judgment decision of HON'BLE. If I'm not mistaken, he's relied on this even here. Does not have pecuniary jurisdiction to urge that the city civil court does not have pecuniary jurisdiction to entertain Section 34 application, since it's not a principal civil court of original jurisdiction, and that the present applications can therefore only be filed before the Calcutta High Court. The decision of the division bench in HON'BLE was, however, delivered on 8 September 2015, whereas the Commercial Courts Act 2015 was published in the Gazette of India dated 31st December 2015 and was deemed to have come into force on 23rd October 2015. Section 21B of the Commercial Courts Act defines commercial courts as the commercial court constituted under Section 3(1) of the said Act. Section 3 empowers the state government in consultation with the concerned High Court to constitute commercial courts by notification as may be necessary for the purpose of exercising jurisdiction and powers conferred on the courts. 3(1)A empowers the state government to also specify the pecuniary value, while Section 3(2) empowers the state government to specify the local limits of the area to which the jurisdiction of a commercial court shall extend. Section 10(3) of the 2015 Act empowers all commercial courts exercising territorial jurisdiction to receive petitions where the subject matter of an arbitration constitute a commercial dispute of a specified value. Section 12(2) provides for basis of determination of a specified value for cases where the subject matter of arbitration is a commercial dispute. Section 21 of the Act declares that the Act shall have overriding effect or on any other law for the time being in force. By notification published on 20th March 2020 in the Kolkata Gazette Extraordinary by the Judicial Department, Government of West Bengal, the pecuniary jurisdiction of Civil Court and Calcutta High Court was notified in exercise of the powers conferred under Section 3(1)A of the 2015 Act. The pecuniary jurisdiction was specified in terms of the value of the commercial disputes and provided that in cases of commercial courts with the territorial jurisdiction of City Civil Court at Calcutta of an amount exceeding rupees 10 lakh but not exceeding rupees 1 crore would concurrently be with the City Civil Court and the Commercial Division with the High Court Calcutta. The other parts of the notification have not been mentioned as they are not relevant to the present matter. Admittedly, the value of the arbitration petition is somewhere between 10 to 85 lakh. This can be, if I may just pause here for a moment, this can be his distinguishing feature. If I may anticipate how he'll try and distinguish it, he'll say, look, paragraph 14 says the value was 10 to 85. And therefore, look, this, if I take that line away, it's actually inures to the benefit of the objection. The ambiguity is on account of petitioner saying that the subject matter of the award is in excess of 10 lakhs, while the respondent says that the value of the arbitration petition is in excess of rupees 85 lakhs. Whatever be the case, the notification which has fixed the pecuniary jurisdiction of the learned City Civil Court and the Calcutta High Court makes it clear that both the City Civil Court and the High Court will have concurrently pecuniary jurisdiction to entertain the present arbitration petition. Section 42 of the 96 Act will, however, settle the jurisdiction in favor of the City Civil Court, since the respondent first approached with an application for interim relief, therefore under 9, and the petitioner subjected itself to the jurisdiction of the civil court also by making a separate application for interim relief in the form of release of the petitioner's vehicle. Again, if I may stop, this was their application. So forget in me making one, they submitting, they themselves went. There can't be a greater submission to jurisdiction there. As stated above, Section 42 mandates that when any application with regard to an arbitration agreement has been made under Part 1 in a court, that court alone shall have the jurisdiction over the arbitral proceedings and all subsequent application arising out of that agreement, and further that no court shall have jurisdiction in such cases. 16, my lord, it is undisputed that Section 9 application arise out of the arbitration agreement between the parties and was a post-award application made by the respondent. The present application under Section 34 for setting aside of the award must also therefore be filed before the civil court, also by reason of the fact that the civil court has pecuniary jurisdiction to entertain the application under Section 34. The division bench of this court in Sushanta Maulik held that the original side of the High Court alone will have jurisdiction to entertain an application under the 96 Act where the value of the subject matter of the dispute in arbitration exceeds rupees 10 lakhs. As stated above, this decision was pronounced before the Commercial Courts Act 2015 was notified on 31st December 2015. Therefore, the decision of this court has to abide by the 2015 Act read with the notification in 20th March 2020, which has since been the guiding document for determining the court competent to entertain a commercial dispute in accordance with the pecuniary limits fixed under the notification. Then your lordship upholds Section 42, dismisses the 34, sends it back. Here I am on a slight better footing because it is their 9. It's the same 9 that is before this court.
Yes.
And I've taken the point of 42. This Section 9, 21E, pecuniary jurisdiction not relevant, possibly after the Commercial Courts Act, is not a relevant fact anymore. Now, my lord, most important bit, and Sushanta Maulik considers the other previous judgments of the Supreme Court, because all these are founded or on the principle of principal civil court, PLE and PAL, of the principal civil court, with two determinations or, two pecuniary jurisdictions running concurrent, applying the Commercial Courts Act. Well, this distinction probably is blurred today. And probably most members of the bar who are here in court today will agree that Section 9 applications are still filed in the civil court based on this.
Yes.
And it is on this understanding that this petitioner also went there. Now, with regard to his ostensible cause for jurisdiction not being there and therefore withdrawal, because withdrawal court no jurisdiction, order 23 will not apply, one paragraph of his application. Paragraph 13 of his Section 9 application before your lordship.
Yes, typographical errors.
Thereafter, typographical error. This is because he's overlapped these two arguments, because jurisdiction and order 23, of course, not substantiated that, but he's overlapped it. With 13 there as his pleading, I find it difficult to accept his argument with regard to at least order 23. Jurisdiction, I think this judgment is the answer. With regard to order 23, because it's not his case there that this court is without jurisdiction have come up. He's withdrawn it on the ground that there were typographical errors. When you are withdrawing, at that moment, if you have the liberty or not to obviate this bar is the test. And that is the judgment which I have relied on.
Yes.
So this is not something that he can really overlap with jurisdiction and say, because without jurisdiction, 23 will not apply. Of course, with jurisdiction, my answer to that is this judgment. Now, my lord, a very interesting, again, argument has been made with regard to jurisdiction, exclusive jurisdiction. I've said it has to be in Chennai because the venue, place, BGS Soma, and everything has been in Chennai. His petition is replete with incorrect submission, averments. And I'll just indicate that because he's argued that and factually incorrectly. Your Lordship will see page 28 and 29. Sorry, page 15, paragraph 55.
Yes.
This is for his jurisdiction. The said agreement was executed and concluded at Regional Office Chaudhary Estate. Within the aforesaid, agreement was terminated from within. Loan agreement concluded within, therefore jurisdiction. Absolutely incorrect. Why? Please turn over, Milan, to page 20.
Yes.
Cholamandalam Investment Company Finance Limited.
Yes.
Your Lordship will find Chennai. Now, place, I'll show because I don't know how these pleadings can be made in an application. Turns over to page 28, Milan.
Yes.
Place of agreement, Chennai. At page 28, top.
Yes.
Schedule E, schedule of agreement,
Yes.
Chennai. Now, loan recall note, one more. What has he said? Yes.
Termination.
Termination, page 29. Chola for a better life. Then there is nothing else. At the bottom, your Lordship will find two stamps with Chola for a better life just under that. Cholamandalam is Chola for a better life. Just under that, finance, again Chennai. At the bottom of the page.
No, that's the
This is the loan recall notice.
that's petition is in a better place anyway. Yes. Yes.
This is also Chennai. So his paragraph 55 is completely incorrect for jurisdiction. His only window that he has, and I'll give him that, his only window that he has is one particular line in an agreement, and I'll indicate, my lord, why I don't think it will be relevant. They share also copies which make it almost impossible to read them. 39.
Better copy देवा.
Better copy.
Yeah.
39.
39.
Yes.
29.
Yes, this is 29. Sorry, my lord. 29, 30.
Yes.
29, 30, I'll place both. All disputes, differences.
Or such other place.
Yes, this is yes. Well, the venue of arbitration is Chennai or such other place, local, location, city, which the company at its discretion may decide from time to time. So there's exclusive jurisdiction in Chennai, or they will decide from time to time wherever they want to go, they will go. Look, on a similar clause, slightly different, but on a similar clause regarding an arbitration clause, but there's a judgment which has held that this is hit by section 28 of the Contract Act. Because this is completely your whim, where you're going to go, what will be your dispute resolution, but there could be a slight difference in that. So I'm not citing it, except that I will try and distinguish this. Kind of a look at 40. Subject to the arbitration clause contained herein. The courts in Chennai alone shall have exclusive jurisdiction over any matter arising out of or concerning this agreement. However, the parties hereby agree, confirm and undertake that the company has a right to file its claim in relation to any amount payable by the borrower or guarantor on any other connection matters mentioned any other competent court at its sole discretion.
Mr. Banerjee, what are you doing? You're yawning and nodding at the same time.
No, I'm not sounding, man. I was just nodding my head, Malad. I
No, you're
wanted
nodding
to
your head to Mr. Banerjee's submission. That I can understand, but yawning, so it's kind of confusing.
I didn't.
Yes.
He finds the arguments boring, but he.
No, I'm
Yes.
finding it
Yes.
interesting. Malad.
Yes.
Well, there is no aim for any amount here. Of course, connected there too, he has it, but for that he'll have to show that there is some jurisdiction here. Otherwise, this venue or seat now, it's interchangeable. I've cited BGS Soma. With regard to exclusive jurisdiction of Chennai, I'm showing that clause, and also to show that his
If you're going to rely on BGS Soma, then that exclusive jurisdiction clause will not be relevant.
Will not be relevant. But if he wants to come under this and show that he could have gone, because we've agreed that he can go anywhere from time to time, he'll go to any court. But his basic, he'll have to show that there is something has happened within. His pleadings are all incorrect. They're contrary to documents. So pleading versus document, the document will stand. And the place is shown different, the termination notice is showing different. So it's not something that gets countenanced by what he's pleaded here.
Yes.
These are my respectful submissions. I'll just sum it up. 42 bar still operates. City Court does not stand denuded of its jurisdiction to try any Section 9 under the Commercial Courts Act as a commercial dispute. This judgment is clear on that. There is no concept of principal civil court once Commercial Courts Act have come in and the pecuniary jurisdiction runs concurrently. Order 23 Rule 1 bar applies because he's withdrawn it on the ground that there were certain technical errors. Apart from that, he has not been able to show that if a court is without jurisdiction and withdrawn it without the liberty to file afresh, Order 23 will not apply. And the last, with regard to his jurisdiction, where he's pleaded all that, but the agreements and the documents speak to the contrary. These are my respectful submissions on maintainability.
Yes, Mr. Banerjee, please come back either tomorrow or on Monday.
Tomorrow, Malad, or Monday, whichever day, Lordship.
Yes. And you can also simultaneously prepare something.
But I would like him to hear me and then prepare, Malad. I think he would be in a better place. Not like that. Not like that. No, I have, Malad, I have a very uphill task before my Lord.
Now I can understand the yawning partly.
Because, Malad, because
I thought you were agreeing with his submissions, but found them boring.
No, I wasn't agreeing. Malad, the only thing is that I have a Malad uphill task because not of his argument, because of his Malad judgment which he has shown. Because Malad, I have to.
If you think in this court that's an uphill task, that's quite unfortunate.
No, it is uphill in the sense, Malad, that I have to show something. Perhaps it was not shown to my Lord. So that is what, Malad, I have to show, because of that reason I'm saying it's an uphill task. Otherwise, Malad, I was not at all agreeing with his argument.
He was yawning.
I wasn't yawning.
Yes. Learned counsel appearing for the respondent, who has taken 3 grounds of objection to the maintainability of the present application, has concluded his submissions. Stop. Next, lists this matter on 15th January 2024 to hear learned counsel appearing for the petition.
Grateful.
Item number 8, Stray Infrastructure.
And I was opposing this.
This is my Section 9 application. I have instructions to withdraw it, Your Lordship.
Without hearing what Mr. Ray's opposition is?
No, it was heard.
It was heard.
Shah was appearing.
Yes, that is the matter. Mr. Shah was.
May the written instruction be taken on record, Your Lordship.
Mr. Mitra, you were in court physically today, earlier in the morning?
Milord, yes. I am just a few meters away. I couldn't make a dash for it. So I took my chances to be online.
So now, Mr. Ray, counsel do their matters few meters away from this court as well?
That's what he's saying, Milord. But I am generally, Milord, I cannot do that because I cannot reach that few meters away, Milord. So I do it from far away.
Yes. Learned counsel, you're the advocate on record?
No.
Or the counsel?
Yeah, the advocate.
I'm sorry. Learned counsel appearing for the petitioner? seeks to withdraw the petition. Stop. It may be recalled that, yes, Mr. Shah, why do you want to withdraw the petition?
My lord, filed in the name of my lord the wrong petitioner, to be very honest. To cut a long story short, there are several reasons for it, but my lord, that is what it is.
On the ground that the petition has been filed in the name of an incorrect entity. Stop. Next, APCOM 20 of 2023 is accordingly dismissed as withdrawn. You want liberty or no?
I don't need
Don't want
liberty
liberty.
because it will be in the name of a fresh entity, my lord.
Dismissed as withdrawn. Stop. The petitioner shall pay costs of rupees blank to blank within 7 days from date.
Item number 9, Mrs. Ugro Capital versus Bharat Electrical.
This is my application under section 9. I find again my learned
But what are
friend
these knowing smiles being exchanged?
because
Let
my
him
lord,
again come up
again,
against each
again,
other.
again he has taken some point, my lord, which needs
There
to
is
be
a
dealt.
movie called Karthik calling Karthik. This is Banerjee versus Banerjee.
And my lord, from the
Yes.
notes that he has written,
This
I'm
is my,
sure, my lord,
this is my
it
junior
is going
has
to
prepared.
be a rough time for me. To maintain
But my lord, all this fun is between the councils. Matter, we've taken the point of maintainability to
On the same grounds?
no, not on the same ground.
No, this is section 9.
This is section 9. I was addressing your lordship. My network there was some technical glitch,
Yes, yes.
and therefore I could not. Your lordship was kind enough to keep it today. But I had taken the point of maintainability. But on the ground that I am not a party to the arbitration agreement 226.
And didn't Mr. Banerjee show some page in the agreement where
I'll show that.
yes.
Here I had shown 2, he would have shown clause 14, and I'll just indicate that. Well, this agreement starts. Sorry. This agreement starts at page 26.
Yes.
That facility agreement is made 27 December between Ugro Capital Limited.
Where are you getting that date from?
At the top note, where facility agreement is, the document is styled.
So it's 26. Yes.
Yes, not 26.
Yes.
25 is the stamp paper.
Yes.
26. Delhi, 25th September, July 2023, between Ugro Capital, carrying on business so and so, referred to as lender or Ugro, whichever one part. The person, entity whose details are listed in Schedule 2 hereunder.
Mr. Banerjee, sorry to interrupt you on the continuing on the yes. You were the one who said ergo.
No, Mr. Chaudhary had said ergo.
Yes.
That's when my video had gone, but I could just hear the exchange between the bench and Mr. Chaudhary.
Yes.
And I understood that just by how they're proceeding, it should be in Bengali. This is
very well. Yes.
The person, entity whose details are listed in Schedule 2 hereunder, referred to as the borrower, which expression shall be so and so. This Schedule 2 kindly turns over. More importantly, at the bottom of every page, your lordship will find a digital signature of respondent numbers 2 to 6. Every page that is there.
Yes.
Now Schedule 2, which is at page 32. Details of the borrower.
Yes.
This is the respondent number 1. Then principal borrower again is one Vedanta Limited because the transaction is something else. Then 14, details for notice stroke communication.
Yes.
A notice or communication shall be issued at the below mentioned address unless the relevant party sends a notice communication with the changed address, that is borrower here for notice. Your Lordship will find my name appears. For notice to borrower, the borrower is someone else. Now all these have digital signatures. More importantly, my lord, the promissory note and the other loan documents only have the name of the respondent number 1. I am in no way connected with the respondent number 1.
No, then why would you be a noticee to the proceedings or
Now I'll
to the
indicate how this was done. Patra dao. Aha. WhatsApp it ota dao amake. I'm not on affidavits. I would have ideally liked to come back on affidavits. Kindly have a look at how this was done. Because in no document, your Lordship will find a sign by any of these respondents 2 to 6. Well, this was the WhatsApp that I got on my phone. I can produce my phone if required.
No, what does it show? 29
It shows an OTP for Aadhaar.
This is 29 July of last year.
29th of July last year.
Yes.
Last year or this year? Last year.
Yes.
Yeah, in 2023. This is the message that I get. I share my Aadhaar details on the basis of this OTP. And this is the result of that. And that entire chain, I'll be able to show the person who had sent me this message was actually an accountant who went ahead and colluded with them. No, the loan recall notice was also never served on me till the Section 9 application is served. I don't know about the loan.
No, but I'm saying that the page which you showed me, Schedule 2.
Yes.
Why would it have your names as the persons who are going to be used for communication?
They've just brought us in, embroiled us in this loan because the money doesn't come to me. The money
no,
goes
but
to
they're all Guptas for starters.
They're all Guptas. So I am for the Gupta.
Yes.
I am for the Guptas here, but I am not connected with this R1. We're the directors of a sister concern. No? We are directors of some sister concern.
Yes.
The loan also does not know money comes to me. The promissory note, all these documents are executed between R1 and the petitioner. This is the only way.
Yes.
They get the OTP and they use that digital signature and put my names in. And your Lordship will see the dates on which the digital signatures have been put in. These are all July 29 at the bottom.
Yes.
And this SMS that I'm showing is July 29.
Yes.
And kindly have a look at the time also. All these times are after 2:05, 14:05. This message is 1:38 p.m.
Yes.
And I'll produce the phone. I have not personally checked, but parties are absolutely conscious of what kind of submission I'm making because I'm alleging fraud here. This is the kind of fraud that we read about in the papers.
What kind of fraud?
That OTP details don't share with anybody.
Yes.
Well, this is why there are ads saying don't share your OTP details, don't share your Aadhaar
You're
details.
saying that you're directors of a sister company.
Of a sister company?
Not a complete outsider or a stranger to whatever is going on.
Well, I have never applied for a loan.
No, I'm saying that not a completely chain breaking kind of a
so what they do is the moment they see that there is a loan application, they try and bring these solvent parties on board. But why my directors have been, or these directors have been brought in personal capacity?
Solvent as in one which mixes easily.
But no. Well, one other document I'll show because this is going to become contentious. Can you have a look at page 22?
Yes.
This is a pre-contract document, but this is the loan application. This also has my name. So the conduit apparently seems to have been perfectly worked out.
Where is your name?
22,
all these
co-applicant 1, 2, 3, 4, 5.
Yes.
as applicants, not as borrowers.
Says applicant 1, applicant 2, etc.
Yes.
Care of.
These are all co-applicants. My name appears.
Oh, so it's co, not care of. Yes.
Co-applicant 1, 2, 3,
Yes.
4, 5. And there's a digital signature at the bottom. But this document was never made over, never known
It's
as a
got-
borrower.
it's got the
No, I'm talking about the
signatures.
loan document.
Yes.
The application is a pre-contract document. So therefore, with regard to that, does not have the arbitration clause. In this, I'm not a party. In any event, my name does not appear as a borrower. It's only somebody to whom a notice is to be issued. I'm not a borrower to the transaction. The promissory note and all that also I'll be able to indicate. But page number to bolo. Page 39, kindly have a look. This is demand promissory note.
Yes.
But this is also issued in the name of the borrower.
Yes.
Kindly gives me a minute. Eta can't now. Amin. No, here I must indicate the name of 2 appears. Subhash.
You're looking at 39.
39.
Yes.
But
Subhash
here your
Chandra
lordship will
Gupta.
find at the bottom for Bharat Accessories, which is R1.
Yes.
The name of 2 appears, but as a director of R1, not in my
Yes.
individual capacity. And R3 to R6, there is no mention. Because this required a signature.
Yes.
So wherever a signature is required, that document is not here. Because I've never signed for this. Only digital signature in the document which has appeared, that is where that loan is there. Now, this is with regard to the aspect of maintainability. On merits, I'm sure Mr. Banerjee will not let me address your lordship first.
No, Mr. Banerjee, not about your learned friend. Yes. You will have to come back on some other day. Yeah, that's done as
Yes,
part
my
of the
maintainability is
not a party. That's your
not a party.
yes, Mr. Banerjee, tomorrow or Monday?
Any day lordship pleases, I have no issues. I'll come back.
Yes, tomorrow. Learned counsel appearing for the petitioner will address the point taken on behalf of the respondent numbers 2 to 6, 2-6 on the maintainability argument. Stop. The respondents say that the respondents are not parties to the loan agreement and should hence you're not saying deletion or whatever. Are you saying that?
Consequently,
Yes,
dismissal against me.
and that the arbitration petition should hence be dismissed as against
2 to 6.
These respondents.
Only one thing, my lord, lordship has stated respondents. He is only appearing for 2 to 6.
I've said that 2 to 6 right at
And
the
my lord,
beginning.
may it be also on 15th, my lord, with the other matters, so that he
Yes,
is only
list this matter on 15th.
grateful.
What do you mean by the other matters? What other matters?
So the other matter lordship has fixed, which my learned friend is on the other side.
List this matter on 15 January 2024 as grateful.
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 Next.
Item number 10 and 11, Chaos Industries Private Limited versus Lakota Infra Technologies.
Lordship, in this matter, I appear for the petitioner.
Yes, I remember.
10, my lord, we have submitted our notes. I have also submitted my notes in 11. Lordship, in item number 11, we are supposed to submit our notes.
Yes, give it. Yes, learned counsel opinion with the parties have already submitted their respective notes. Stop. List this matter on 18 January 2024 under the heading for judgment.
Great.
Item number 11.
My lord, on the last
I
in
remember.
this matter, my lord, they had taken a point as to pecuniary jurisdiction. We had already filed one note prior occasions, my lord, indicating the facts. They have not made any, they've not disputed any of the facts stated in that note. They've only relied upon.
That's fine. I will note that
I've
it's only for
I've
pecuniary jurisdiction.
dealt with that in this subsequent note, my lord. I've
No,
not
no,
repeated.
I have disputed the facts as well. I've said that in there is an admission in their emails which
I've
is
dealt with that.
restricting their claim to 22,140.
That I've dealt with, my lord. I've dealt with it. Lord, I have not repeated the prior note, my lord.
As to the on the facts?
On the facts. I have not repeated the prior.
Yes, same order.
Deeply grateful.
Grateful, my lord.
The petitioner's note is taken on record.
Obliged. Obliged.
Item number 12, Probir Kumar Jana.
My lord, I appear on behalf of the petitioner, my lord. On the last occasion, my lord had granted me a liberty to use a supplementary affidavit, bringing on record certain facts which was inadvertently omitted from the main petition, my lord.
Yes.
My lord, may I have the leave to file the supplementary affidavit, my lord?
No, this is a section 11 on
No,
9.
my lord, this is a section 9 application, my lord.
Yes.
My lord, the respondents have perpetually not been appearing, my lord, despite affecting service quite many times, my lord, and despite, my lord, publishing advertisement on the newspapers, my
Yes.
lord.
What does your supplementary affidavit say?
My lord, my supplementary affidavit says, my lord, in course of my argument made on the last occasion, my lord had posed a question before me that whether I had made any endeavor to cancel the development agreement prior to coming to the court. And my lord, unfortunately, that document was inadvertently omitted from being a part of the main petition.
Yes.
My lord, in the year 2019, my lord, the petitioners had written to the respondent to commence the work as per the development agreement, which was executed by and between the parties back in the year 2013. But my lord, they had maintained a stoic silence despite being in receipt of the representation. My lord, by this supplementary affidavit, I have also brought on record a general diary which the petitioners had caused to lodge before the concerned police station
Have
at
you
Bali.
terminated the agreement?
No, my lord. Now, my lord, the question is my lord, that despite the issuance of this letter where I had requested them to commence the work as per the development agreement, since they did not do that, despite being in service of the notice, my lord, I am assuming that the agreement has terminated by their conduct and by virtue of their non-performance.
No, they have not replied to your
No,
notice.
no. They did not
Show me
reply
that
to
notice, please.
My lord, that notice is a part of this particular supplementary affidavit, my lord. My lord, it is appearing at page 12, my lord, of the supplementary affidavit. It's a notice, my lord, dated 8th August 2019.
Page 12.
Yes, my lord. This is the second supplementary affidavit which I am filing
No,
today.
after 11, there is page 19.
No, my lord.
After 11, there is page 19.
This is the supplementary affidavit which I am filing today. My lord, I'm extremely sorry, my lord. This is something.
What is wrong with your advocate on record? You can't even number the pages. After 11, it's 19.
My lord, I had not seen this, my lord. I tender my apologies in this regard, my lord.
Correct the pages and come back tomorrow.
My lord, may I seek one indulgence, my lord? Tomorrow I'm in some difficulty. Can it be posted on Monday, my lord? Subject to your lordship's convenience.
It'll go to the next week then.
My lord,
I don't know what kind of work is this.
My lord, I'm extremely sorry about it, my lord, because
Pay some costs. Pay some costs. Give me the matter, and you can pay some costs. I will hear it today. Pay costs. Yes. The pagination, even though the petitioner had been granted liberty to file a supplementary affidavit, the pagination is not correct. Stop. The petitioners shall hence pay costs of rupees blank to blank within 7 days from date. Yes, continue, please.
Yes, my lord, we had issued this letter on the 8th of August 2019, my lord.
Yes.
And in this letter, my lord, we had requested them to commence the work in terms of the development agreement which was executed in the year 2013. My lord, a power of attorney had also been executed by the petitioners in favor of the respondents to commence the construction. But my lord, despite being in receipt of the letter, my lord, they made no endeavor to commence the construction whatsoever. My lord,
Raise
despite
the
there
letter, Mr. Sengupta,
Yes, my
please.
lord,
Your
it's
saying so will not help.
It's at page 12, my lord. And my lord, we'd indicated
It's not
that
12 in my brief, so please don't be silly enough to go on saying it's page 12.
my lord, from page 19 in your my lord,
Yes.
brief, my lord. My lord, kindly turns to page 20 of your brief, my lord, and my lord,
Yes.
kindly comes to the paragraph at the bottom of the page. My lord, that now, after signing the development agreement, more than 5 years has been lapsed, but till now you have not supplied the copy of the sanction plan in respect of the said holding, though I and my lord, the petitioner number 2 repeatedly demanded from you for supplying the sanction plan. I also do not know whether you truly got the sanction plan or not in respect of the said holding. You keep me/us in dark. You also fail to provide me, us, our allocated portion and non-adjustable sum as stated in the said development agreement. And for the reason I/we are facing huge financial loss day after day. My lord, now at the bottom of this particular page, my lord, we signified our my lord, intention to them that if within a span of 15 days, my lord, they fail to either reply to us.
Where? Which
My
paragraph?
lord, therefore, by this letter, you are, my lord, it would be the last page of the letter, my lord, at the bottom paragraph.
Yes.
Therefore, by this letter, you are advised to reply to me whether you will do the construction work accordingly to the said development agreement and according to the sanction plan or not. If you are interested to do the same, then when from you will start the construction work and will complete the same, and when you will deliver my allotted portion and will pay the balance non-adjustable amount as agreed upon to me. Kindly reply to us within 15 days from the date of service of this letter. Otherwise, we will
Very well.
take.
So this is of 2019.
Yes, my lord.
Then why did you wait for 4 years after this?
My lord,
If they did not reply to this notice
Yes, my
and you have given them 15 days time, then why did you wait for 4 years?
my lord, perhaps, my lord, I do not know about any sacrosanct or cogent reasons what prevented the petitioners to come before the court back then. But I'm
But
assuming,
then,
my lord,
but
due
then
to the
that
ensuing
is
pandemic or something, my lord, might have precluded them.
pandemic or something.
My lord, the
Pandemic ended in 2021. What were you doing after 2 years?
my lord, that I'm
But then
honestly not
you will
privy
not
to.
get the relief, Mr. Shengupta. That is the point. The delay disentitles you to relief, to discretionary relief.
My lord, the fact is, my lord sees and observes their conduct, my lord, despite having tried to get them to court, my lord.
No, the only conduct is that they have not replied to this letter. There is no document to show that they have actually not done the work. Show me that document.
My lord, they have commenced construction on the last occasion. Also, I had advised
Mr.
to your lordship.
Shengupta, try to understand. You
Yes,
will
ma'am.
not get the order. Show me the one document to show, apart from their not replying to this letter, that they have not commenced the work, or they have not completed the work, or they have not kept to the
My lord,
timeline.
that is what the situation is. They just simply did not commence the work. That is what the
Mr.
situation is.
Shengupta, do you think you're saying telling the court will be enough for getting an order?
No, my lord, I suppose, my lord,
Then,
that will not suffice.
then there is no order. At best, I can direct affidavits. That's all. But there, I cannot give you any order because there is no document before the court.
My lord, the fact only remains that this development agreement dates back to the year 2013, and there has been made no endeavor whatsoever
Very
on the
well.
part of the.
You're saying that will not do. You will not understand what the court is trying to tell you. And the relief sought, that is what I'm seeing, is not to give any further effect to the registered development power of attorney.
And the
And-
development agreement, my lord.
And the development agreement, but on what basis? You have to show documents, even if the respondents are not appearing in the matter. I could have given you the order. Had you should just show me one document to show that they have not either commenced or show me the agreement. Till when were they supposed to complete the work?
My lord, within 24 months
24 months from?
from the date of execution of the agreement.
Give me the date, please, Mr. Shengupta. What
Yes,
is
my lord.
this? Are you not ready in the matter?
No, no, absolutely, my lord. I'll just indicate that to your lordship.
You are not even ready in the matter.
My lord, it is at page number 27
Give
of
me
the
the
petition.
date of the agreement.
My lord, 13th or 26th August 2013, my lord.
So they were supposed to complete the work
in 24 months. My lord, that comes to 2015, 25th
Show me the
August.
clause, please.
My lord, that is at page number 27 of the petition at clause 4.5.
And what were they supposed to develop?
Well, they were supposed to develop a G+4 residential cum commercial building at the plot.
Very well. So you want the court to restrain them from proceeding with the development?
Yes, my lord, from actually trying to de-alienate the
Show me one document to show that they have not done the work.
My lord, they
at all.
obtained the sanction plan in the year 2016, my lord. That has been made a part of this particular petition.
Yes.
My lord, but unfortunately, that sanction plan now stands expired. My lord, that sanction plan is at page 59.
Very well. After that, just show me some correspondence, something apart from that one letter from your side, where they have either said something or they have denied or you have said something else.
No, my lord.
Nothing.
There's no other
And
correspondence
the only
apart from
letter
that.
which you have shown, Mr. Shengupta, is of 2019.
Yes, my lord.
And you have filed this application in 2023.
Yes, my lord.
So what entitles you to relief? Yes, the petitioner seeks interim orders in terms of an agreement for development capitals dated 26th August 2013, which was executed between the petitioner where is petitioner number 2 not mentioned in the agreement?
Yes, my lord. The petitioner number 2 is here.
Yes, which was executed between the petitioners as the landlords and the respondent number 2 and the respondent as the developer/contractor. Stop. The petitioner, the respondent by the said agreement, next, comma, the respondent was to complete the project and hand over the same to the petitioner within 24 months from the date of the sanction plan. Stop. This is clause 4.5 of the agreement, capital A. Stop. Next, learned counsel appearing for the petitioners submits that the sanction that the respondent obtained the sanctioned plan sometime in 2015.
2016, my lord.
2016. Stop. Council submits that the sanctioned plan expired by the time the present application was filed and that the respondent has not undertaken any work in pursuant to the agreement. Stop. Next, the respondent has remained unrepresented from the time this matter was first considered, comma, which was in September 2023. Stop. The petitioners were given several opportunities to serve the respondent. Stop. Next. The petitioners were also given a chance to bring additional documents on record to take the petitioner's apostrophe case forward by way of a supplementary affidavit. Stop. The supplementary affidavit, however, discloses only one document of 8th August 2019 from the first petitioner to the directors of the respondent stating that the respondent was being given 15 days time from the receipt of the letter to take necessary action in terms of the development agreement. Stop. The respondent was also to inform the petitioners whether the respondent intends to start the construction work and complete the same and deliver the petitioners allotted portion to the petitioners. Stop. To the petitioners. Stop. Next, there is no other document which has been brought to the notice of the court with regard to continuing correspondence between the parties. Stop. Significantly, comma, the letter dated 8th August 2019 gave the respondent 15 days to reply to the letter, failing which the petitioner number 1 / the petitioners will take necessary action against the respondent. Stop. The present application was, however, filed on 28th April 2023, comma, which is almost 4 years after the petitioner's letter. Stop. Next, Section 9 of the 1996 Act contemplates discretionary orders from the court, where the court considers it necessary to intervene to protect the subject matter of the arbitration, which is to commence, which has either commenced or is to commence, or has even been completed between the parties by way of an award. Stop. The court, the discretion is exercised on the material placed before the court. Stop. Next. In the present case, comma, apart from one letter of 8th August 2019, comma, the petitioner has not shown any other documents, has not placed any other documents to show that there has been failure on the part of the respondent to act in terms of the development agreement. Stop. The petitioner, the delay of 4 years in filing the application, comma, even if the pandemic is taken into account, comma, has also not been explained either in the petition or facts which have been orally pleaded in court. Stop. Next, this court is hence not inclined, the petitioner seeks an order of restraint on the respondents, on the respondent from dealing with or disposing of or encumbering the petitioner's immovable property, which forms part of the development agreement. Stop. The court is not inclined to pass this order to give this relief in the absence of further or better particulars which would have established the petitioner's case, petitioner's case for such relief. Stop. AP 261 of 2023 is accordingly dismissed in view of the above reasons. Stop.
I'm extremely grateful, my lord.
The supplementary affidavit is kept on record. Cost part Next.
Item number 13, Ugro Capital versus Asha Court.
Lordship, this is my Section 9 application. Lordship, on the last occasion, the respondent number 5 had appeared in person. Lordship, in this matter, the respondent number 1 is a proprietorship firm and the proprietor had died. And thereafter, we had impleaded the legal heirs of the main borrower.
No, so this Mr. Raja had appeared for who?
Lordship, he is the respondent number 5.
Yes.
Lordship, on the last occasion, had recorded that there has been approach by them for settling the matter, and we should take steps for settling the disputes between the parties. Lordship, thereafter, we had contacted them. There has been, Lordship, if I could hand over the emails that has been exchanged between the parties. Lordship, there is no concrete proposal from them, and therefore the settlement could not be done. They have written that they would regularize the payment by 22nd of January. Lordship, if they need to regularize the payments, as on date, the principal due is 15 lakhs and odd. So they need to pay that.
If it's 50, how much? 22nd of
January.
You
Lordship.
wait, I'll come back after that. Where does it say 22nd? Yes. Yes.
And Lordship, it doesn't say how he wants to make the payment, nothing.
Very well. The advocate on record of the petitioner places a mail from the respondent number 5. This Manohar B. Nagaraj is who?
Lordship, he is the respondent number 5.
Respondent number 5, described as the co-founder of the respondent number 1. By which the said respondent has promised that the loan repayment will be regularized by 22nd January 2024. Stop. Next, the last order of 23rd November 2023 records that the sender of the mail had appeared in person and had submitted that the respondents have given proposals for settlement of the dispute between the parties. Stop. Next, no one, however, appears for the respondents today. Stop. Next, list this matter on 30th January 2024.
Item number 14, Ugro Capital versus Right Health Platter.
Lordship, this is my Section 9 application wherein already an injunction on their bank accounts and properties have been given by the orders of this Honorable Court. Lordship, we have already issued a Section 21 notice. Either they agree on the arbitrator or the injunction orders can be extended.
Yes,
My lord, I have, pursuant to my lord's direction on the last occasion, my lord, I have categorically taken instruction. I cannot agree to the, it is nothing with regard to the person name, but we are not agreeing with the section 21 notice, the appointment, my lord.
So you don't want the arbitration?
My lord, only thing, my lord, kindly permit me to make submission, 2-line submission on law. Even this.
The Kolkata part?
My lord?
Yes.
Yes, yes.
Jurisdiction.
Yes, that's why I'm asking you. Kolkata, the Kolkata part. Yes.
And nothing had happened in Kolkata, either the original side or even the greater Kolkata.
Nothing had happened means what?
No cause of action in Kolkata, neither of the
So,
parties.
Mukherjee, that is not the law now.
Now, my lord, that is my second limb of argument. My lord, even this point has already been considered by your lordship in a different judgment. My lord, I'm really grateful to my lord that I got the time. I found this issue has been covered by your lordship in my lord's judgment reported in 2020 SCC Online Calcutta 1790.
Which issue?
My lord, the greater Kolkata part. My lord, this issue was raised before your lordship, my lord. Here, although after hearing the parties, my lord was pleased to reject the submission. But if your lordship kindly comes to paragraph 25, reject the submission of the respondent, my lord, that the term.
Show me the paragraph, please.
My lord, paragraph 3, the submission was recorded. Submission of the respondent therein was recorded. According to Mr. Such and such, the learned counsel appearing for the paragraph 3, my lord.
Yes.
Appearing for the respondent, no part of the cause of action has arisen within the ordinary original civil jurisdiction of this honorable court, as the entire transaction has taken place at the petitioner's head office in Sector 5, Salt Lake, and at the respondent's registered office in Sector 2, Salt Lake. Counsel relies on the arbitration clause and the exclusive jurisdiction clauses in contract, which.
No, don't place the whole paragraph. Come to the reasoning, please.
Now, my lord has been pleased to consider the judgments passed in BGS Soma, that is paragraph 20. And it's a longish paragraph. If your lordship kindly turns the page.
Hurry up, Mr. Mukherjee. Where?
Yes,
You're relying on
if your lordship kindly turns the page, my lord, paragraph.
Which paragraph?
Paragraph 20.
Yes, so tell me which part.
My lord, the next page, paragraph 20 starts, the page numbers are not there. My lord, paragraph 20 starts at. Okay.
You're not ready or what?
My lord, page 5, kindly come to page 6.
Give me the paragraph number.
Paragraph 20. 20. And kindly turns to page 6, my lord. My lord, second line from the top. In the cases discussed in that decision, the question was whether the chosen seat of the arbitration could be bypassed in deciding the law governing the arbitral proceedings. Relying on the passages from Enarkan and Shashua, the Supreme Court held that once the seat of arbitration is chosen, it would amount to an exclusive jurisdiction clause insofar as the court at that seat are concerned. The illustration given in that paragraph 49 of BGS Soma shows that the Supreme Court was considering a case where the cause of action had arisen in multiple courts, including the court.
How is this paragraph in your favor?
My lord, my submission that this honorable court does not have the jurisdiction would have been held to be bad had some cause of action had arisen in Kolkata.
What? I can't understand. What?
My lord,
if some cause of action arises in the jurisdiction of multiple courts, then any court within which the forum selection clause.
Show me the arbitration clause, please.
Well, it kindly comes to page 32.
15.2.
Page 32, my lord.
Yes, so seat and venue in Kolkata. What is the problem?
Well, seat and venue is in Kolkata.
Yes.
But this clause would have been in aid to my learned friend had something happened to in Kolkata.
What are you saying, Mr. Mukherjee? Parties have chosen the seat and venue to be in Kolkata. What do you mean by cause of if something had happened in Kolkata? That's contrary to the law. And you're showing me my judgment, which is completely against you.
Well, subject to correction by your lordship. My lord,
Please don't waste the court's time. Yes, I'm confirming. I'm confirming the interim order.
One sentence.
Yes.
My lord, all the judgments, my lord, have been pleased to consider have been considered in all this in my lord's judgment, and the term seat that gives the exclusive jurisdiction to that particular honorable court, my lord, in all those judgments, my lord has been pleased to find that something has happened or some cause of action has happened.
Very well. Yes. Please don't waste the court's time. Yes. So where is the order of injunction?
Lordship, it's 3rd of October and thereafter on 22nd of December.
The matter was listed today on the prayer of on the prayer made on behalf of the respondents. Stop. Next, on the last occasion, comma, learned counsel appearing for the respondents had made an argument stating argument that clause 15.2 of the facility agreement, capitals, dated 27th May 2023, executed between the parties, should be has a measure of ambiguity, since the seat and venue of arbitration has a measure of ambiguity. Stop. According to counsel, comma, the seat and venue of arbitration, comma, chosen by the parties, comma, to be in Kolkata, comma, can only be given effect to where some cause of action had arisen within in Kolkata. Stop. Next, the council also relies on a judgment of this court reported in 2020 3 Cal LT 256 Srei Equipment Finance versus Sarah Infraventure Private Limited. Stop. Next, on considering the judgment, the judgment does not help the respondents, since the court had relied on the series of decisions pronounced by the Supreme Court, including in BGS versus which paragraph was that?
Paragraph 20.
Including in BGS, SGS, SOMA. Where do I get the citation now?
Well, I'll find for your lordship.
Yes, sir, blank where the Supreme Court had conclusively held that the seat/venue clause of the arbitration agreement would decide the court would decide the jurisdictional court. Stop. Next, as noted in the earlier orders, comma, the now okay to the last other paragraph. Therefore, comma, this decision goes against the respondents. Stop. Next, as noted in the earlier orders, comma, the petitioner has already invoked the arbitration agreement under by way of a notice under Section 21 of the 1996 Act. Stop. The notice was sent on 21st September 2023. 21st December 2023. Stop. Hence, comma, the parties are ready to proceed to arbitration subject to further orders passed by the court if there is a disagreement as to the choice of arbitrator. Stop. Next, in any event, comma, Section 9 within brackets 2 of the Act casts a responsibility on the petitioner who obtains an order under Section 9 within brackets 1 to have the arbitral tribunal constituted within 90 days or 60 days?
Lordship, 90 days.
Within 90 days, 90 days from the date of the interim order. Stop. Next, AP 681 of 2023 is accordingly allowed and disposed of by confirming the interim orders dated 3rd October 2023 and 22nd December 2023 for 6 weeks from today or until further orders passed by the arbitrator, comma, whichever is earlier. Stop.
But I have given the citation.
Citation.
And my lord, I appear only on behalf of the respondent number 2 and 3. One I do not.
Yes, one is not appearing. Yes. The submissions made on behalf of the submissions noted above were made only on behalf of respondent numbers 2 and 3. Stop. Yes, I have a meeting. I completely forgot about it. Yes,
Non-commercial matter, item number 1, Ranjit Kumar Paul versus Pawan Kumar Paul.
I appear on behalf of the petitioner. Yesterday, my lord, we had served because they had some issues with the service, my lord. Copy, my lord.
Mr. Bag, are you representing all the?
My lord, only the respondent. My lord,
Oh, yes, one
respondent.
My lord, it's an application for extending the mandate of the arbitrator under section 29A, my lord. Now, my lord,
29A.
29A. Now, my lord, I tell you, before I show you the documents, I tell you, lordship, what had happened in this arbitration proceeding. The learned arbitrator was appointed on
No, why, Mr. Deb? Why do you want to show me documents?
necessary because, my lord, there is some confusion because according to us, my lord, the learned arbitrator
You're the
himself,
claimant.
I'm the respondent.
Yes.
The learned arbitrator stated, my lord, during the subsistence of the mandate, this is our understanding, that my mandate has terminated, therefore you should approach or take steps in accordance with law. Now, my lord, why I say within the time, that's why, my lord, I need to show you, my lord, certain documents.
Yes.
And before that, I would like to place you the facts, my lord. Now, my lord, here, my lord, the learned...
So there is a controversy as to whether the mandate is subsisting or not.
According to us, no. According to learned arbitrator, yes, my lord.
And what about the respondent?
My lord, according to us, the mandate is over, my lord.
Over. Yes.
Now, my lord, here, my lord, the learned arbitrator was appointed by an order dated 11th April 2022.
Yes.
He, my lord, proceeded and first sitting was held on 21st of April 2022.
Yes.
I will show you the minutes. There, my lord, the learned arbitrator gave necessary directions, my lord, for filing the pleadings. It records the fact that the statement of claim has to be filed within a certain period of time. Counter statement or defense has to be filed thereafter, and then, if necessary, rejoinder has to be filed. Initially, the statement of claim has not been filed within time as directed by the learned arbitrator.
Yes.
Instead, they proceeded, my lord, to file an application for an interim award, which finally was passed. Now, after taking 3-4 adjournment, my lord, finally they filed their statement of claim. The respondents, my lord, filed their statement of defense with the counterclaim. Obviously, then, my lord, question arises about filing the rejoinder. That direction was given. Even today, my lord, the rejoinder has not been filed.
But Mr. Deb, but 23.4 says claim and
yes,
claim and statement of defense.
That's true. That's true. But, my lord, the moment, my lord, somebody, my lord, files the statement of defense with the counterclaim, my lord, it takes the shape of a plaint, my lord. Obviously, then the rejoinder becomes the written statement. And plaint and written statement both should be considered as pleading that has been contemplated in the Code of Civil Procedure.
Yes.
And civil procedure also contemplates the fact that the moment defendant files a counterclaim, then plaintiff is entitled to file the written statement. That provision is there.
Yes.
And that has also been dealt with to an extent by a decision of this Honorable Court. I will come to that later. Now, my lord, even today it has not been filed. Now, the important date, my lord, Lordship would find the date of entering into the reference, that is, my lord, I would take it, my lord, on 21st of April 2000.
Mr. Deb, how is all this relevant? Just give me the date of the statement of claim.
No, statement of claim, my lord, exact date, I do not know. Just give me, my lord, 2-3 minutes time, my lord. So, my lord, according to section 23(4), my lord, pleading has to be filed within 6 months. 23(4).
No, 23(4), 29A1.
Yes.
Talks about 23(4).
Lordship.
Only to the extent, only for the purpose of what the pleading will be.
Absolutely.
That is statement and statement, the statement of claim and the defense. What you're saying, I will hear you on that. That because there's a counterclaim, therefore something to that effect.
And that has been admitted by them. That has not been controverted.
Yes.
Now, my lord, this is first point I will show. My second point is, my lord, that if you take the date, 21st of April, then 6 months, my lord, will take us to, my lord,
Why 21st of April? That is a date of statement of claim.
No, that is the first entering into the reference, my lord.
No. See, the 1 year under 29A1 is 12 months from the date of filing of the pleading, completion of the pleadings. 29A1.
Yes. 20.
The date of entering reference is not relevant.
No, my lord, I'm sorry, my lord. 23(4) says the statement of claim and defense under this section shall be completed within a period of 6 months from the date the arbitrator or all the arbitrator, as the case may be, receive notice in writing of their appointment.
No, that is not relevant. I'm telling you, Mr. They've come to 29A1.
29A1.
Yes.
The award in matters other than the international commercial arbitration shall be made by the arbitral tribunal within a period of 12 months from the date of completion of the pleadings under subsection 4 of section 23.
Yes.
So I say it has not been completed. That's my first point.
No, this 6 months from the date the arbitrator receives notice.
Correct.
I am discounting this. This may go against you. I am discounting this.
Very well.
I am only taking 23(4) to be relevant for the extent of the statement of claim and defense as to the pleadings which are referred to in 29A1.
Lordship.
Understood? So I am construing it in your giving you the benefit.
Now, my lord, kindly, my lord, straightway, my lord, kindly, my lord, comes to.
So therefore, give me the dates now.
Yes. Now, my lord, date, my lord, I would show you the admission, accepting the fact that the rejoinder will be constituted as a part of the pleading. That is also important. Kindly come to, my lord, page 42 once.
Mr. Dev, will you give me the dates or not?
Date, my lord, appointment date was, my lord, on
appointment date is not relevant. Statement of claim.
Statement of claim, my lord. Just, my lord, give me a time, my lord. My lord, the exact date, my lord, has not been mentioned. What has been mentioned in the minutes by the learned arbitrator held on, that is why I wanted to show you, on 24th of August 2022, appearing at page 50, that the claimant has already filed its statement of claim. That's why I need to show you the minutes, my lord.
No, but if you're the respondent, you don't know when the statement of claim that must have been served on you. Must have been affirmed on a certain
my
date.
lord, I tell you, lordship, there is some confusion, and my lord, there is a
Yes,
5th of August 2022.
5th August.
5th of August 2022.
Very well. Yes. Because it's been served on you, so you must be knowing you participated in the arbitration.
There, but I'm not going into that, my lord. The advocate on record, my lord, didn't act in terms, my lord. We wrote a letter. However, I'm not going into.
Very well. What is the statement of defense?
Statement of defense, my lord, we filed on 6th of September. Now, my lord, there was a direction for filing rejoinder has not been filed. Section 17 application has been filed, and finally the learned arbitrator passed an interim order. Now, my lord, whether it should be constituted as a pleading or not, whether they have admitted that fact or not, may I should show your lordship, my lord. Kindly, my lord, come to page 52 once.
No, so where you mentioned Mr. Deb, you mentioned a counterclaim. When was that filed?
Counterclaim was filed on 6th of September.
So say that, please. Yes, then.
Kindly, my lord, come to page 42 once, my lord.
Yes.
Page 40, the minutes that's dated 19 June 2022, third sitting. Kindly turns over, kindly straightway comes to page 42. At the top, my lord. Lordship has got it?
Yes.
Since no pleadings have been filed by the claimant as and by of a statement of claim, and no statement of defense and counterclaim has yet been filed, the question of looking into the schedule for fixing the remuneration, that's not important. So that has been, there's a direction, all parties were present.
No, but Mr. Bagh said it's 5th of August 2022.
I'm not disputing that date. What I am saying, my lord, the question of terminating the mandate will arise, my lord, from within a period of 1 year from the date of completion of the pleading. 29A4.
So tell me, when was the statement of defense or the counterclaim filed?
I told you, my lord, 6th of September.
Yes, so 6th of September, then it will be 6th of September 2023.
Right. Now, my lord, my lord, I say, my lord, here you have to take into consideration the filing of the rejoinder, because that is, my lord, really takes the shape of the plaint. And the rejoinder which the claimant will be filing, that is the written statement. That's also part of the pleading.
So rejoinder they have not filed.
They have not yet filed. So that stage of terminating the...
No, Mr. Lake, no. If they had filed the rejoinder, then you could have had an arguable case of saying that very well, because we found a counter claim, we filed a counter claim, therefore their rejoinder should be seen as a written statement to my counterclaim, which is a plaint. In this case, they have not filed the rejoinder at all. For whatever reason, that's their option. They have chosen not to file the rejoinder. So the date of filing of the counterclaim and the statement of defense, that will be seen as the completion date for the pleadings under section 29A1, or rather the 1 year from 29A1 will be the 6th September 2023. If they had filed a rejoinder, then you would have definitely had a case. In fact, I think in one of my judgments, obviously last year,
Satnam Global.
there was also a case where, but in Satnam Global, I only remember Faces of Counsel. I don't remember all these points and all that. But in that case, I think there was an admission made by one of the parties that there was that filing of the rejoinder will not take it outside the scope of 29A something, and I had set out that part
in an application. I say, my lord, subject to what falls from your lordship. I have other points, my lord, that they have given consent within, my lord, the time 12
very
months.
well. If they have
There is an
consent,
admission, I say.
No, if they have given consent of 12 months of 6 months, will that take you outside the
within time 18 months, 12
very well.
months?
Show me the consent, please.
My lord, kindly, my lord, comes to page 26. Page 26, annexed to P4, 18 sitting at the top left-hand side, my lord. Dated 14th May.
Yes.
On that day, my lord, the interim order was passed. Now, my lord, kindly comes to page 27 once. Last paragraph.
Yes.
Within time, what had happened, that has been recorded. It is submitted on behalf of the lordship has got that, my lord. It is submitted on behalf of the claimant that the statutory period of 12 months for making and publishing the final award is due to expire sometime in August 2023. This tribunal wanted to extend the time by 6 months as and by of abundant caution in the meeting itself, although August 23 is still a few months away. However, Mr. Ghosh, appearing on behalf of the respondent number 1, my client, and 3, submits that he is not in a position to give consent without consulting his clients. Such matter is therefore left open. So their consent has been recorded. We didn't give any consent. We took some time. That is well within 1 year. Now, kindly,
but consent is not for the claimant to give. It is for the respondent to give.
We gave that afterwards. We gave that.
Very well. Where is that? But consent, Mr. Deb, has to be from during that period when the mandate, you can't give it later.
No, within 1 year. Within 1 year. Now, that
not within 1 year. Consent is 1 year plus 6 months.
18.
So yeah, it has to be before the 1 year ends.
That is what I was submitting.
Yes.
Kindly, my lord, comes to my lord. Page 28.
Yes.
Tuesday, August 3, 2023. Lordship has got the mail, my lord. Second mail.
Yes.
From Raghunath Ghosh, my advocate on record, erstwhile, to the learned arbitrator. Copy given, my lord, to their advocate.
3rd October, you're showing me?
Yes, 3rd October.
Yes.
Copy given to them also. On going through the minutes of the proceeding, it appears that on 6 September 2022, the claimant was given an opportunity to file his rejoinder to the statement of defense of the respondents, which was filed on 6 September 2022. Lordship wanted to know the dates. However, the claimant till date neither filed any rejoinder nor did give up their filed rejoinder. Nothing in this time has passed from which it appears. So, the final award will run. In the meantime, an interim award was passed, Your Honor. Hence, it appears that Your Honor's mandate is not yet over. Please consider the above and fix a date for hearing of the earliest. Then, my lord.
So when was the consent given?
Consent given, my lord, on 3rd of October, Lordship would take it. That we said kindly proceed. And
It doesn't say that this is consent for 6 months or whatever.
My lord, it doesn't say in expressly, but impliedly it's a consent. We said, my lord, kindly proceed, my lord, and that too, my lord.
Yes, but 3rd October, the mandate had already ended.
Not that according to the learned rabbit, my lord, his mail is at the bottom, 2nd October. In reply to that, we had written, first email is dated 2nd.
No, your mail is 3rd October.
That's true.
Yes.
And that we had replied to the learned arbitrator's mail dated 2nd October 2023, where he said that my mandate.
Yes, but your mandate ended on 6th September 2023.
My lord, if lordship takes this view, my lord, then 6 September, 1 year, yes.
No, what view can I take, Mr. Dev? That's what the Act says.
My lord, my argument, my lord, is slightly different. I would say, my lord, that there is an admission about rejoinder taking to be as a pleading. And since they have delayed the proceeding, everything, my lord.
Where have they said that we will file the rejoinder?
Kindly, my lord, comes, my lord, to the minutes, not in express words, but finding of the learned arbitrator recorded. Page, my lord, 52. Kindly come to the last sentence, my lord, at page 51. Last two sentences, my lord. The claimant has already filed a statement of claim. The respondent have not yet filed a statement of defense within the prescribed time or at all. As a last chance, an opportunity is given to the respondent to file a statement of defense on or before 2nd September. Rejoinder, if any, is to be filed by 12th September 2022. Irrespective of the question of filing these pleadings, this tribunal will once again meet on 6th September 2022, on which Mr. Bag's client will make known about the counter offer. There was an ongoing settlement process.
No, but where does it say that?
Part of the pleading, that's the finding. Finding of the learned arbitrator.
Finding? Where is the finding?
Irrespective of the question of filing these pleadings. That's the finding of the learned arbitrator.
No, so that's not a finding. In any case, that's a misconception, because 23(4) says something else, and that point you could have argued in this court that if they had at all filed the rejoinder, then that rejoinder would have extended or would have stretched the definition given to pleadings under section 23(4). But they have not filed the rejoinder. So that argument will not even be, that will not lie, that argument.
Well, they have not filed, that's true, but they have also not given up their right to file the rejoinder.
No, Mr. Dev, that's speculative. Very well, Mr.
But I would rely on this.
Yes, of course, you can rely on a judgment.
Rely on this judgment.
Yes.
And in between that, there's a why the matter has been delayed, Millard. There's an ongoing settlement that has been recorded by the learned arbitrator. Offer and counter offer has been made because we resigned, Millard. That is also on record.
Very well, Mr. Dev, if the mandate has terminated, the settlement will not help you, or will not help you, as in also not help Mr. Bag. Show me the decision. You have a right to cite decisions.
Have a look at this judgment, Millard. Satnam Global Infra Projects, Millard.
Yes. Here the facts were different. I remember they had not only made an admission, the respondent or whoever it was, the respondent must be, but had also mentioned 29A in that affidavit. I remember that.
Yes, that's there, Millard. Point taken, section 12.
And I think I had set it out.
Yes, Lordship has set it out, Millard, after recording the argument of section 12 and section 9, 12 of limitation and 9.
Yes, paragraph 9.
Yes, Lordship has recorded that pleading.
Yes.
The paragraph is reproduced here and above in an application where Millard's probably extension has been sought for, their finding has been recorded. Millard, I would say, Millard, that the recording of the fact by the learned in presence of the parties, that these are the part of the pleadings, would constitute, Millard, their
That's in any case a misconception of the law. Yes.
Now, Millard, there, Millard, there's 2-3 paragraphs, Millard. What would be the pleading? Lordship has recorded, Millard, paragraph 6, 7.
Yes.
Everything, Millard. Lordship says the pleading meaning thereby, Millard, that statement of claim and statement of defense, that in paragraph 7, Lordship has recorded that, Millard.
And I am sure, Mr. Dev, that the learned arbitrator, I don't even want to say anything about the law because that is not fair on my part. And that should not also be said. But I'm sure the learned arbitrator used the word pleadings in a general sense. Like I would say very well, when will you, are the pleadings complete? Which would mean an affidavit in opposition and a reply. I would not, when I make these statements, I would not say that very well strictly under the section 29A1. The courts often and arbitrators often use these words.
That's true, my lord, but
Yes.
lordship would consider, but this is not a surjoined, my lord. This is not a sir rejoinder. This is why I say it's part of the pleading, my lord.
Yes, but Mr. Deb, the whole scenario would have changed had they filed that rejoinder. Had they filed that rejoinder, I would have definitely heard you on that point. And in Satnam Global, that was also taken into account.
Yes, that's true.
Definitely.
That's true.
Yes, Mr. Bag, 1 minute.
My lord, just one, just order 8, my lord, that's about the pleading, my lord.
Order 8.
Order 8, my lord, what says about what is pleading? Plain written statement, my lord, that, sorry, order 6, my lord, pleading. Now, my lord, the Order 6, Rule 1, my lord, it says pleading mean plain and written statement, but it subsequently discusses, my lord, when somebody, my lord, files a counter claim, my lord, takes it, then it takes the shape of a plaint. And obviously, then the other party who is given an opportunity files the written statement. That is the written statement. Here, my
Without
lord,
a doubt, what you're saying about Order
so-
6 is definitely there.
so, my lord, then, my lord, I would humbly submit, my lord, then what would happen? You don't give up your right. You don't file the pleading. In the meantime, settlement process is going on. And if you count the days, my lord, 6 September and then it's 6 October. Yes, if you take that days, we are, and that consent part, I would say, my lord, that they have given their consent, my lord, within 1 year. And that has been recorded. Just because I didn't consent, couldn't extend it.
Very well. Mr. Deb, but the respondent's conduct has also been recorded in that minutes
That's true. That's
at
true.
page 28.
And that's true that we have taken time. They have taken
Yes.
time, all of us. And that is because of the settlement process
Very
which
well,
has
but
been
that
going
will
on.
not be relevant for 29A. Yeah, Mr. Bag, 1 minute.
Milord, we did not file a rejoinder to the counterclaim because Milord, they resiled from the counterclaim as is evident from the interim award. So be that as it may, Milord, we did not file the rejoinder because we accepted whatever they had prayed for, they resiled and we accepted the position. Kindly note, Milord, interim award stands, no section 34 filed, it is not challenged. In this situation, the only reason why, Milord, the mandate, they are seeking for extension of the mandate is so that they get an opportunity now to challenge it because the 120 days are gone. They can't challenge it. That's my first submission. Second submission, Milord. Kindly see their conduct. In the 18th minutes, when we were ready, Milord, to give consent,
120
they said
days.
120 days, Milord. From the interim award. Milord, the interim award is dated
Very well.
14th of May 2020.
Not required. Whether you've got an interim award or not, that is not relevant for this.
Here only the dates are relevant, and Milord, I will not
And
go
I will
beyond
not also record any reasons why they are making this application. That is completely extraneous to this application.
The dateline is this. The reference pleadings over. We take the cutoff date at 6th of September 2022. That's the cutoff date, Milord. From there, Milord, the award, the interim award was 15th May, and the date comes to an end on 7th of September 2023. Whatever they do after 7th of September 2023 is, Milord, beyond that period under 29A. That's my submission.
Very well. And what about the consent?
Milord, we did not give a consent. Consent has to be, in fact, that is recorded by, Milord, kindly take up the recording at page 28. It's the mail given by the learned arbitrator. Page 28, Milord. The second last line is the mail at the bottom of the page. At this stage, unilateral consent on your part to extend my mandate is no longer feasible.
Page 28.
Milord, page 28. This is the mail given by the arbitrator.
Yes.
On the 2nd of October, Milord. After the period is over, because my submission is that the period is over on 7th of September. This is 2nd of October. The second last line there, Milord. At this stage, a unilateral consent on your part to extend my mandate is no longer feasible. You're required to take steps in accordance with law. And before that, also the previous page, may I only indicate?
Yes.
The last paragraph. It is submitted on behalf of the claimant, Milord, the previous page.
Yes.
The last paragraph, it is submitted. This is a part of the 18th minutes of the meeting, Milord. Submitted on behalf of the claimant that the statutory period of 12 months for making
and publishing the final award is due to expire sometime in August 2023. Tribunal wanted to extend the time by 6 months. As and by way of an abundant caution in this meeting itself, although August 2023 is still a few months away. However, Mr. Ghosh, appearing for the respondent, who's the petitioner before your lordship, submits that he is not in a position to give his consent without consulting his client. Matter is therefore left open. In such event, such consent is given, it shall be conveyed in writing to this tribunal, who will then make a formal recording of the same in the minutes. There is no minutes recording of formal consent given by them. So the mandate has expired. And this mandate shall terminate unless they have made out a case, which in my very respectful submission, beyond the 12 months period, can't be a further extension without consent. So no 6 months, additional 6 months given. It comes to an end. Only this date is important, my lord, in my very respectful submission, 7th of September 2023. That's the 12 months from 6th of September 2022 when the SOD was filed, the statement of defense.
Very well. Mr. Dev, 1 minute, please.
One thing, my lord, there, my lord, I would like to argue, my lord, sorry, I should have pointed out to your lordship, my lord, if lordship is with me, my lord, then it's, I have not, if lordship is with, not inclined to pass orders, my lord, then, my lord, obviously, my lord, the question of interpretation of sufficient cause will come, my lord.
Sufficient cause for what?
For extending the mandate.
Sufficient cause?
My lord, 29.
And under 29A5?
Yes, obviously, my lord. Because 29.
Mr. Deb, my view is different.
That's true, my lord. Then, my lord, if I may make one submission, because there are contrary view also, and my lord, that judgment, my lord.
No. Mr. Deb, that judgment was totally different.
No.
Here, there is absolutely, the facts are totally different. That judgment is different. That the application has to be made during subsistence mandate. Here, there are too many facts. The pleadings are complete. The pleadings were complete as of 6th of September 2022. And Mr. Deb, you can always take up my order in the Supreme Court and club it with whatever is pending before the Supreme Court.
Very well, my lord.
Yes. The other matter where your matter, which I had kept
in March
pending in March, that was different. That was directly a fallout of Rohan Builders.
Just, my lord, if your lordship dictates, my lord, just one second,
Yes.
my lord, if I may take, my lord. Sufficient cause, my lord, why I say accepting the fact that I'm out of time. If you take 6th September is the last date, and within 12 months, I have to come. If I can't come within 12 months, obviously, my lord, then I have to give an explanation explaining the sufficient cause for the court to come to the finding. Yes.
Mr. Deb, that is contrary to my view.
That's
That
true.
sufficient cause, everything follows, everything must happen during
Within the time,
Very well. And if Rohan Builders is set aside, then everything comes back to life. You can always come to the court
Then, my lord,
and make these arguments.
Then, my lord, if lordship dismisses this application, I tell your lordship, because that's one of my point. Then, my lord,
No, Mr. Deb, no. You can always take it up. You take it up in the Supreme Court and you club it with Rohan Builders.
My lord, may I hand over copies of the Rohan Builders judgment? I'm carrying those.
No, why? I'm not going to look at Rohan Builders now. Yes. And in any case, Mr. Bagh, I don't encourage the practice because I have given a judgment. Therefore, counsel treating that as the main, as the trump.
I'm carrying all the other judgments, but I did not trouble your lordship
Very
with the
well.
judgments.
Yes.
Now.
The application is for extension of the learned arbitrators mandate under section 29A within brackets 4 of the Arbitration and Conciliation Act, 1996. Stop. Next, the petitioner within brackets respondent in the arbitration, close brackets, through learned counsel, prays for extension of time on the primary ground that the pleadings as defined under section 23 within brackets 4 of the Act and specifically referred to in section 29A within brackets 1 should also include the rejoinder of the respondent within brackets claimant in the arbitration, close brackets, full stop. According to counsel submits that the respondent submits that the claimant in the arbitration did not file its rejoinder, and hence rejoinder to the petitioner within brackets respondent in the arbitration close brackets counterclaim, and hence the period envisaged under section 23 within brackets 4 of the 1996 Act should still be considered as continuing, and the calculation of the timelines made on that basis. Calculations of the timelines made under section 29A made on that basis. Stop. Counsel places minutes of the sittings to show that the learned arbitrator referred to the counterclaim as part of the referred to the proposed rejoinder of the claimant as part of the pleadings, and treated it as such. Stop. Counsel also places a mail of 3rd October 2023 from the petitioner's advocate on record to the learned arbitrator, requesting the arbitrator to fix a date for hearing of the matter despite the hearing of the matter. Stop. Next, learned counsel appearing for the respondent within brackets claimant in the arbitration, close brackets, places the relevant dates, places the dates which are relevant for consideration of an application, with dates which are relevant for an application under section 29A within brackets 4 of the Act. Stop. Counsel also places minutes of the hearings to show that the learned arbitrator was aware at least on as far back as on 14th May 2023 and later on 2nd October 2023 that his mandate had expired. Stop. Counsel also places minutes to show that, where is that minutes which says that consent was not given?
Page 26.
Yes, also places minutes to show that
at page 27, the last paragraph.
The respondent within brackets petitioner before this court, close brackets, had submitted to the arbitrator that it was not in a position to give, places minutes to show that learned counsel appearing for the respondents, appearing for the respondents in the arbitration, had made a specific submission to say that he was not in a position to give his consent without consulting the respondents. Stop. Next. The timelines, yes.
Sorry, but one thing I wanted to, I just said about the ongoing settlement process that was going on, that also prologue, kindly record.
Very well. ওই যেখানে petitioner counsel বললাম ওখানে আরেকটা লাইন লিখে রাখো. Counsel also submits that there is that the parties are exploring a settlement. Stop. Last কি বললাম? Last line টা. The next paragraph. The timelines under section 29A of the Arbitration and Conciliation Act, 1996 are well defined. Stop. The arbitrator is under a statutory mandate to make the award within 1 year, within 12 months. Does it say 12 months or 1 year?
12 months.
Within 12 months from the date of completion of pleadings. Stop. Section 29A within brackets 1 refers to pleadings as defined in section 23 within brackets 4 of the Act to mean the statement of claim and the statement of defense. Stop. Section 29A within brackets 3 contemplates extension of the 12 months by an additional period of 6 months, provided parties agree to such extension. Stop. The parties are given an option to approach the court under section 29A within brackets 4 for extension of the arbitrator's mandate. Stop. Next, in the present case, the undisputed dates for filing of the pleadings are as follows. Stop. The statement of claim was filed by the respondent before this court on 5th August 2022, and the statement of defense along with the counterclaim was filed on 6th September 2022. Stop. Hence, the 12 months under section 29A within brackets 1 would end on 7 September 2023. Numbers 7/9/2023. 7 September 2023. Stop. The argument of the rejoinder of the claimant's proposed rejoinder to the counterclaim being treated as part of pleadings, as part of the pleadings, as defined under section 23 within brackets 4 of the Act, would have certainly been an arguable point if the claimant had filed its rejoinder in the arbitration. Stop. The fact remains that the claimant, for reasons which are not relevant for this proceeding, did not file its rejoinder. Stop. The definition, the timeline under section 29A within brackets 1 of 12 months from the date of completion of pleadings would hence be calculated from 6th September 2022 and end on 7 September 2023. Stop. Next, the submission made on behalf of the respondents in the arbitration that the learned arbitrator returned a finding on the claimant's proposed rejoinder being part of the pleadings is not acceptable. Stop. The minutes this is Mr. Davis, the 19 June 2022 minutes.
Yes, my lord, page
42.
42,
Yes.
52, lordship
Yes,
can consider me.
yes, thank you. The minutes dated 19th June 2022 makes it clear that the learned arbitrator used the word pleadings, quotation marks, in a general sense and not in accordance and not with any specific reference to either section 23 within brackets 4 or to section 29A within brackets 1 of the 1996 Act. Stop. The minutes also do not, the minutes also make it clear that the procedural order cannot be treated as a finding made by the learned arbitrator. Stop. Next. The mail written, the mail shown on behalf of the respondents in the arbitration of 3rd October 2023 from the advocate on record of the respondents asking the requesting the learned arbitrator to go ahead and fix a date for hearing at the earliest certainly cannot be taken as consent as contemplated under section 29A within brackets 3 of the Act. Stop. Section 29A within brackets 3 specifically uses the word parties quotation marks, consenting to the extension of 6 months beyond the 12 months. Stop. Consent, comma, in this consent under section 29A3 hence cannot mean unilateral consent given by one of the parties, by only one of the parties. Stop. The in any event, comma, this mail is prefaced by P-R-E-F-A-S-E-D, prefaced, F-A-C-E-D, prefaced by the arbitrator's mail of 2nd October 2023, where the arbitrator has clearly stated that his mandate has come to an end and that the parties must take steps in accordance with law, and that the parties must hence take steps in accordance with law. Stop. Next, the argument made on behalf of the claimant in the arbitration with regard to the claimant enjoying an interim order and the respondent being aggrieved by such is not relevant for the present proceeding, since the scope of the present application is restricted to whether the learned arbitrator's mandate can be extended under section 29A of the 1996 Act. Stop. Next, the এর উপরে একটা লাইন লেখো তো, এই যে আগে যেটা বললাম তার উপরে লাইন. The other argument made on behalf of the respondents in the arbitration with regard to Order 6, Roman 6, of the Capital Code of Civil Procedure, 1908, is also not relevant since section 23 within brackets 4 of the 1996 Act, read with section 29A within brackets 1, defines and restricts the scope of pleadings. Stop. As stated, moreover, comma, as stated above, comma, the entire complexion of the matter, the complexion of the entire matter would have changed had the claimant filed its rejoinder and the respondent had argued that the rejoinder should be treated as part of the pleadings. Stop. In the absence of any rejoinder, filed by the claimant, comma, this argument loses relevance. Stop. Next. The minutes dated 14th May 2023 records that besides comma যেখানে unilateral consent না কি এটা বললাম না 26A3 ওটা পরে লেখো তো এটা 26A3 ওটা কি বর্ণালী নিয়েছে নাকি না তুমি নিয়েছো বর্ণালী পাঠে আছে কোথায় yes 26A3 ওর পরেটা লেখো yes besides comma same line same paragraph besides comma the minutes dated 14th May 2023 clearly records that the respondent in the arbitration had refused to give a clear indication of its consent subject to further instructions from the client. Stop. Next, the delay on the part of the parties Satnam Global Infra Projects versus Bharat Heavy Electricals 2023 SCC Online 2023 SCC Online Cal 4668 where the court had considered had accepted the rejoinder being part of the pleadings was decided on completely different facts. Stop. In that case, comma, the respondent in the arbitration had filed an application for extension of time where the respondent had made a specific statement that the claimant's rejoinder would be taken as part of pleadings under section 23 within brackets 4 of the 1996 Act. Stop. In that case, in the facts of that case, comma, the claimant had also filed its rejoinder. Stop. In the present case, comma, the claimant, the present case substantially differs from the facts of Satnam Global. Stop. Next, the argument of sufficiency of cause as contemplated under section 29A within brackets 5 of the 1996 Act. Also presumes subsistence of the mandate. Stop. The view of the court Rohan Builders versus what is the other party's name? Berger Paints.
Yes, Bajaj Paints
Yes,
India.
Rohan Builders versus Berger Paints. Stop. The court is informed that Rohan Builders is pending consideration before the Supreme Court. Stop. If Rohan Builders is set aside, comma, this argument as well as this argument, the argument on sufficiency of cause will be open to the respondent in the arbitration, but not before that. Stop. Na ki bola? If this ki bola? Na this argument is subject to the decision of the Supreme Court, to the final decision of the Supreme Court in Rohan Builders. Stop. Next, since the mandate of the learned arbitrator has admittedly came to an end on 7th September 2023, comma, any further extension of the mandate, either by way of a belated unilateral consent under section 29A within brackets 3, or an application for extension under section 29A within brackets 4, will not lie any further, will not be entertainable, will not be within the legal premise any further. Stop. Next, AP 837 of 2023 is accordingly dismissed. Stop. There shall be no order as to costs. Mr. Deb, you tagged this appeal along with the other matters
But the
in the Supreme
difficulty is Lord, the financial constraint. Only one thing, subject to what falls from the court,
Yes,
that
yes.
cannot be a consideration, of course. If Lordship adds one sentence, in the event Lord, the view of this court is set aside or a different view is taken by the Supreme Court,
Why should I have to record it in my order,
will not
Mr. Deb?
preclude the petitioner in coming to the
No,
court.
no, no.
Otherwise,
Mr. Deb, that you will always have. If I don't have to record it in my order, if the judgment in Rohan Builders is set aside, then why yours?
Lordship is observed.
Very, and I've said it. That's
Yes.
why there was no need for me to mention Rohan Builders. I only mentioned it for your benefit.
That's
so
true.
that
I have
so that if
sufficient-
because Rohan Builders, why should I go on harping on Rohan Builders in each and every judgment?
Absolutely, it's not.
Not required at all. But that if only for your interest, I mentioned that judgment, and if Supreme Court sets it aside, then everything else you can always have the liberty to come to the
was
court
recorded subject to that.
on 29A5 or whichever other. I don't remember that section anymore, but whatever, you can always come to the court.
Very well, Malad.
All right.
Very
Very
deeply
deeply obliged. Deeply obliged.
Item number 2, HON'BLE Constructions Private Limited.
Lordship, this application is for the extension of the mandate of the arbitrator.
Mr. Das, you please let me know when Rohan Builders is set aside, because otherwise I will be going on passing orders every day, and all of them will be wrong orders. All right.
Lordship will record the submission of the affidavit service.
Can't you see that I'm speaking to your colleague? Yes. What is
As of
this
now,
for?
it is only admitted. Hearing has not started. As of now, it is only admitted.
Very well. What is the point here?
Lordship, the extension has come to an end on 31st of.
Can't hear you.
Lordship, the extension has come to an end on 31st of December 2023.
What is it within the mandate?
Yes, ma'am. Within
First extension.
Yes. Second extension. Lordship.
Second.
Yes.
Where is the first?
First extension is Annexure C, page number 14, where your Lordship was pleased to grant 4 months extension.
Yes, what is the stage of the arbitration now? Arguments have been completed. Written notes of submissions have also been filed. Only the preparation and publication of the
When? Filed when?
My lord, the delay was on my part. I filed it on 23rd of December. I sought an extension and filed it. I was supposed to file it on 4th of December. So it is not really the petitioner's fault, my lord. And that is why the learned arbitrator was not able to complete and publish the award by 31st December.
before that, the application was filed. So the mandate
So the
is
mandate ended on 31st December.
31st December, but the application was filed prior to that.
This is a second application for extension of the learned arbitrator's mandate. Stop. The first extension was given on 29th August 2023. Stop. The court is informed that the mandate expired on 31st December 2023. Stop. The present application was made on 20th December 2023. Stop. Next. Learned counsel appearing for the respondent in the arbitration. Respondent within brackets also respondent in the arbitration, close bracket, submits that the notes of arguments were filed by the respondent on 24th December 2023 and that the matter is presently pending publication of the award and that the arbitration is presently pending publication of the award. Stop. Next, considering the submissions made, comma, AP 866 of 2023 is allowed and disposed of by extending the mandate for 3 months from 31st December 2023.
Somewhere it has gone down that I had filed the notes on 24th December. It will be 23rd December.
24th December.
Item number 3, Rajesh Gupta.
My lord, in this matter, Mr. Priyanka Saha appeared for the petition. I am praying for not this week, my lord. He is some personal.
I'm going to record your submission today. And every time you come and say the same sentence, I'm going to impose costs on you.
Monday, you will take up the matter.
Yes, Mr. Dashkut, what is this about?
My objection was on the ground of jurisdiction. Since then, Miller, adjournments and after adjournments, because it's personal difficulty, I cannot, Miller, I do not want to stand in the way.
Very well. Mr. Dashgupta, you had made your submissions on what?
No, Miller, because they wanted to make submissions citing some judgments. Those never came. So, Miller, I have to give reply upon that. So, if they make their submission on those new judgments, then I
Pay
will.
some costs, Mr.
Monday, last
Mr. Mondal. No, pay some costs. Before Monday, you pay the costs. Yes, this is the second prayer. This is the second adjournment. No, this is the third. This is the third consecutive adjournment sought for on behalf of the petition. On behalf of the petitioner. Stop. Next, list this matter. When do you want it?
Monday.
List this matter on 15th January 2024. Stop. The petitioner will put in costs of rupees blank to be paid to blank within 7 days from date.
Grateful.
Item number 4, Indwell Constructions.
Should I appear for the respondent?
Not I wait to appear for the petitioner. This is an application for
Can't hear you.
This is an application, my lord, for substitution of the learned arbitrator upon his death.
Death?
Yes.
Yes, show me the last minutes, please.
But the last minutes is not annexed here, my lord. My lord, I can show from the paragraphs that when the last meeting occurred.
Yes, when did the learned arbitrator die?
The learned arbitrator is passed on 18th of November
18th of November.
18 November. What was the name? Where? Show me a document, please.
My lord, your lordship will kindly find that at page, my lord, 70.
70?
70. That is the order of appointment of arbitrator. Your lordship will kindly find it in the last paragraph. My lord, accordingly, Munishankar Dwivedi, retired district judge, is appointed arbitrator. Now, my lord, the learned arbitrator.
What was the stage of the arbitration?
Yes, my lord, here, my lord, the pleadings are completed, and my lord, I have also given examination in chief. My lord, the examination in chief was started on 9th of February 2023, and that was the only date, that was the last effective hearing date. Thereafter,
9th February 2023?
9th February 2023.
But you're saying that the arbitrator passed away on?
Yes, he
November.
passed away. He was suffering from illness for a very long period of time.
Passed away on?
Passed away on 18th November 2023.
What is the claim? You're the claimant?
Yes, I'm the claimant. My lord, the claim is about 1.73 crore. It is a 1.73 crore. I have pleaded that in paragraph 11.
Very well.
And,
Yes.
And my lord, it is, my lord, once extended, Otherwise the mandate would have terminated. It is extended till, my lord, March of 2024, March 12 of 2024 by consent.
This is an application for appointing a substitute arbitrator pursuant to the unfortunate passing away of the erstwhile learned arbitrator on 18th November 2023. Stop. Next, learned counsel appearing for the parties informs the court that the last effective hearing was held on 9th February 2023 and that the mandate of the learned arbitrator was extended till 12th March 2024. Stop. Next, considering the, what was the stage of the arbitration you said?
Well, I am cross-examining their witness.
Very well. The respondent is presently cross-examining the claimant's witness. Stop. Next, considering the submissions made on behalf of the parties, comma, AP 867 of 2023 is accordingly allowed and disposed of by appointing blank in place and stead of the erstwhile learned arbitrator, subject to paragraph to the other way, to be communicated by 14th January 2024.
One indulgence, Your Lordship, because one line that parties be directed to collect the records from the office staff of the learned arbitrator.
Yes, the parties are given liberty to collect the records from the office of the learned erstwhile arbitrator.
I'm grateful to you.
Item number 5, Mr. Siemens Healthcare Private Limited.
Take paper on behalf of the petitioner, Lordship. Your Lordship, Lordship, I have already served, Lordship. I am handing over the affidavit of service, Lordship.
So you are appearing for the respondent?
No, respondent could not hand over the documents and the wakalatnama due to some personal reason. So kindly fix this matter on Monday.
No, there are many respondents. Who are you appearing for? Yes, Monday? Yes, who are you appearing for?
For respondent number 1.
You're the counsel?
No.
The advocate on record of the respondent number 1? No, what is your name? You have not filed the wakalat number. What is your name?
Ma'am, Lordship, in this matter, my counsel also leave due to some medical problems. So kindly fix this.
What is the name of the counsel?
Counsel, Moitra Ghosh. Moumitra Ghosh.
Is a he or a she or a what?
He.
Yes, Mr. M. Ghosh, who proposes to appear for the respondent number 1, but is absent in court today, comma, shall file the wakalatnama by 4:30 p.m. on 15th January 2024. Stop. List this matter on that date.
My lord, item number 1, Sir Shamrat Chaudhary, my senior.
Item number 1.
Item number 1.
Ki bolche thaki?
Lordship, item number 5, Lordship, I also applied, Lordship. Kindly record that one also, Lordship.
Item number 5.
Lordship.
You don't think your name will be recorded in the order? Next.
Item number 6, Nandita Mystery versus Sanjay Shah.
I'm for the petition.
What is this matter?
This is a matter for extension of time of the arbitrator because of the pendency of one civil revision application before this honorable court, my lord.
Yes.
The learned arbitrator who was appointed in the year 2018, July 2018, he could not proceed with the matter, and in the mid of the arbitration proceeding, entire proceeding has been stopped. So the direction, yes.
Stop for what?
Because of the pendency of the stay order. And my lord, the learned arbitrator, the learned...
No, but all this is not relevant for 29A. 29A is all for the all
My
to
lord,
do
this
with
is
the
not a
timelines.
29A application. He has filed a Section 11 application. The application itself, my lord, a misconceived one. And kindly see the prayer portions. জজ সাহেব দেখবেন।
When did the mandate end, or is it continuing?
Yes, my lord, as per the order of this honorable court, the arbitrator was supposed to conclude the proceeding within 8 months. But since the
Show me the order,
my lord,
please.
that is at page 52, my lord. Last but two paragraphs, my lord. Accordingly, Mr. Partha Pratim Roy, advocate of Bar Association, room number Ato, is appointed as the sole arbitrator to adjudicate the dispute between the parties. So here the name, and next page, my lord, last but 4 lines, page 53. Accordingly, the learned arbitrator is requested to conclude the arbitration proceeding preferably within a period of 8 months from the date of completion of the pleadings of these respective parties. And arbitrator's letter is at page.
No, but what does 29A say? 29A for has the mandate been terminated?
That has not been terminated.
How do you know that? 29A, have you read and come? Better get ready and come. Yes. And the order of the coordinate bench was passed before the amendment to section 29A, which brought in 29A1. Amendment is of August 2019. Yes, you get ready and come back. When do I keep the matter?
Monday, my lord.
Monday. Will you get the time to get ready? There's a long weekend.
Well, it will, yeah.
Get ready. Yes, list this matter on 15th January 2024 as prayed for on behalf of the.
My lord, may I indicate that the respondent stays as Malda. My lord, he has come court today, my lord, by anyhow, and he has received the copy on Monday, the day before yesterday. My lord, as of now, we have not filed, my advocate has not filed Vakalatnama, but he assures, my lord, that it will be filed by tomorrow. This is my duty to point out.
Yes, the respondent, learned counsel appearing for the respondent, undertakes to file the Vakalatnama by 5:30 p.m. Respondent, adjunct respondent, by 4:30 p.m. tomorrow. Stop. Learned counsel, Mr. Basu, who proposes to appear for the respondent, undertakes to file the Vakalatnama by 4:30 p.m. tomorrow. Stop.
My lord, my advocate on record will file it.
Yes. Yes, any other matters before the appellate side matters are taken up? Yes, 7 to
7 to that. Item number 7, Mrs. NP Engineering Company.
Appearing for the petitioner, my lord. Appearing for the petitioner, my lord. This is my application for appointment of arbitrator, my lord.
Yes, you come back on Monday, please. Yes.
Monday.
Monday?
Monday, okay.
Yes. List this matter on 15 January 2024.
Let the affidavit of service be kept on record.
Affidavit of service is kept in record. Yes, appellate side. Mr. Mukherjee, which one are you waiting for? You're looking very dejected.
Waiting for item number 8. But I'll come back on the next.
8. Sombad din. Monday's matters will be there on Monday. Yes. Yes.
Appellate side matters, assigned matter, item number 1. Sunil Shah versus Union of India.
Yes.
My lord, I beg to appear for the respondent, Central Warehousing Corporation. But on the previous occasion, your lordship had directed for accounts reconciliation. Now, vouchers were given to us, my lord. May I be permitted to submit
I've just received the copy.
a copy of the accounts reconciliation statement? My lord, there are few vouchers which are missing. My lord, those we could not reconcile.
The original side. Yes.
My lord, there were certain vouchers missing for certain periods which we could not reconcile, my lord. That is still with the Food Corporation. Now, that apart, my lord, the rest what we have received, we have reconciled it. Now, my lord, the payments which we have received from the Food Corporation of India, we have already disbursed it in favor of the writ petitioner. Now, my lord, what has been withheld is the demerit charges.
You're for the warehousing,
Warehousing corporation, my
corporation.
lord.
Yes.
So what has been withheld, my lord, is the demerit charges.
Yes.
That has been categorically shown in the, my lord, the reconciliation statement.
Yes.
So lordship kindly takes up the report, the statement. The 9th column. What is statement?
Yes.
Lordship, if your lordship kindly takes up the statement, the 9th column from the left.
No, what is it that you want to say? We don't have the time to go into these figures now. Have you shared the figures with everybody?
I've just given them.
Just now?
Yes.
When will you come back? Next Monday, the next Wednesday then?
Very well, your lordship.
Why have you not
I
not
received
given
it
the figures?
today itself. I received it today itself.
Yes, Learned Counsel appearing for the Central Warehousing Corporation. Hands up a calculation sheet to Learned Counsel appearing for the other parties, for the petitioner and the FCI. Stop. Since counsel have not been given sufficient time to consider the calculation, list this matter on 17th January 2024.
Deeply obliged.
Item number 2.
Rose
Rosedale Garden Apartment Owners Association versus Newtown Kolkata Development
This
Authority.
is our modified written notes of argument as per your lordship's direction.
Have you changed your case or is
Yes.
is it still the same?
But the format has been changed, not the case. Lord, I have not annexed the judgments that I have relied on because those were annexed with the earlier written notes. Lord, otherwise it would have looked very bulky.
Yes.
If my lord wants, my lord, I can file those judgments separately.
You don't want to file a fresh set of judgments?
No, it's there, my lord. I can stitch it and file it with you for your lordship. Lord, this is the set of judgments, so I didn't annex it. But
Yes.
Lord, this is the written notes of.
Very well, give it. And you were the only party who was directed to file another note?
All parties.
NKDA lordship direction was given to file.
My microphone, please.
NKDA lordship is pleased to direct the NKDA to file a short notes lordship with regard to this matter lordships. I have which has been prepared, and so I am filing this thing before your lordship. No copy nahi.
What is this thing? Yes, give it.
My lord, I am appearing on behalf of respondents number 7 to 9. I was also directed to file revised notes, my lord. My lord, my written notes are not ready today, my lord. I am praying for a short extension to file it.
How much of revision are you doing, Mr. Das?
I am trying to shorten it as much as possible. That is the revision I am doing.
Yes.
I appear for the respond number 6, the developer.
Mr. Banerjee, Orindam
Mr.
Banerjee?
Banerjee. I'm
Yes.
led by Mr. Banerjee. My notes are ready.
But nobody is there to willing to take
I-
your note.
I-
That's the problem. NKDA is respond number
1, 2, 3.
and you are 6 and you are 7 to 9.
One,
Very-
two, three.
Lord, may I hand over the judgments, Lord?
Not necessary. New judgments?
No, those same judgments that we rely on the earlier occasion also.
Yes.
Then লিখে দাও একটা compilation.
If I don't accept these set of judgments, then you will not lose the matter. That's what you're saying.
But I say that the law is so settled by your lordships only, Lord, I will not lose the matter. I don't need to rely on any judge.
Good to be confident from time to time. Yes. Learned Counsel appearing for the petitioner, NKDA, and the respondent number 6 have handed up their revised notes. Stop. This is matter on 17 January 2024 for the notes of the respondent number 7-9.
17. 17.
Item number 3, Professor Dr. Shruti Bandyopadhyay versus Vishwa Bharati and others.
I beg to appear on behalf of the petitioner. I beg to appear on behalf of the petitioner, madam. My lord, on the last occasion, they concluded the argument. I have to give a reply today, madam. My lord, the first point that they raised in their response to my petition is that where the petitioner do not have any legal right to get that additional increment. My lord, in this regard, I submit that UGC regulation empowers not only the university in the instant case, but also the person claiming such additional increment to get that increment on the basis of her or his educational qualification. So since legal right flows from a statute, so there cannot be any dispute or doubt to the fact that I have a legal right because of my educational qualification to get that additional increment. My lord, second point that they raised was that I represented personal inconvenience for the purpose of grant of this additional increment, which does not feature for grant of additional increment in terms of UGC regulations. My lord, it is true. While on receipt of the offer of appointment, I brought to their knowledge that yes, I'm accepting that subject to from a particular period, from a particular date, and also that yes, I have to maintain 2 accommodations. So if possible, grant me 5 additional increment. But was this the consideration on the basis of which the additional increment was granted? The answer is no. The Executive Council, which I have annexed at page 41, 42 of my writ petition, from there it will be apparent that the Executive Council, since there is a procedure that the Executive Council will decide an issue and thereafter the Executive Council will sought for approval or advice from the selection committee whether an individual can be or whether a professor can be granted an additional increment or not. This Executive Council did not take note of my inconvenience. What they took note of is my educational qualification. Were they permitted to take note of this fact or of these conditions? Yes. Regulation 6.4.1 of the UGC regulation permitted them. So they took a conscious decision to grant me this 4 increment, not 5, my lord. 4 increment. So this point which they have raised of personal inconvenience does not arise at all. What was the consideration? Consideration was my educational qualifications, how I stand in my field.
Mr. Chakraborty, you will have to make it short today because we are going to rise early. So that I have.
May I just then indicate one more point and continue on the next?
Yes, yes, of course.
My lord, they have harped on the word inducement, that I induced the university, grant me this increment. Was it the actual facts? My humble, and on the basis of which, 2015, on the basis of which they relied upon a judgment reported in 2015, volume 17, SCC 1. They relied, I'm stand corrected, 17, volume 15, SCC.
Doesn't matter. Don't place a judgment today.
No, I'm not placing. In this, I will place the judgment on this next date. My humble submission in this regard will be that inducement attracts dishonesty, persuasiveness. I will correct this word next time, my lord. In the given case,
what is the word you want to correct?
Persuasiveness, my lord. I never pursued the university that until and unless you grant me this with a dishonest intention, that until and unless you grant me this increment, I will not join. I made a representation to them that kindly consider whether I can be granted this increment or not. Had they not granted me this increment, I would have easily returned back to my earlier employment because I was getting a higher pay scale. I was on lien when I joined in this service and when this increment was granted to me. So to attract inducement, there has to be a dishonest intention. Where is there? Nowhere in the opposition, they have stated that I have dishonestly made any representation to claim that additional increment.
Very well. Mr. Chakraborty, you save your,
Yes, madam.
hopefully the best point for the last, for last. All right. How many best points do you have?
I will rely upon one point, which is, I may indicate, they have not produced the resolution till date, wherefrom it will transpire that the Executive Council has decided to pass that order which is impugned. No resolution has been produced to delay. So whether there was any meeting or it was an act of someone who is not in power today, I don't know, because years have passed.
Yes, call on the next. Yes.
Grateful, madam.
Come back on coming
Any day as
Wednesday.
per my lord's convenience, any Wednesday.
Yes. Learned counsel opinion for the petitioner will continue with his submissions on 17 January 2024. Next.
Grateful.
Item number 4, Kanchan Oil Industries Limited and another versus Union of India and others.
Only 5 minutes are left, I will suppose.
5 minutes and one more matter. So let me call on that one more matter and then come back to you. Yes, Porter Dakoto.
Item number 5, JK Builders versus the Union of India and others.
Tender Millard, breach of fundamental term Millard. The proprietorship firm Millard has given Millard the financial credential. The partnership firm has bid it. There is no document Millard of partnership uploaded. And Millard, further clarification cannot be sought for Millard. So Millard, there is no
Mr.
document.
Ghosh, I will not hear your matter unless you make it more interesting than Mr. Mojumdar's arguments in the
This is a
preceding
matter, Millard. There was a fundamental breach. Lordship was about to pass the order, the determination changed. Then we are before your Lordship,
Very well.
12
And,
months contract.
Are you
9 months
going
of
to argue on behalf of the respondent?
I am led by Mr. Devasis Banerjee, behalf of the respondent number 3 and 4, my lord.
Very well. I will এটাকে প্রথম matter করে দাও তো সামনের বুধবার. Yes, list this matter on 17th January 2024 as paid for. Stop. Yes,
Great.
আগেটা রাখো।
Much.
ডাকো পাঠাটা ডাকো। 1 minute, Mr. Mojumdar. ডাকো পাঠাটা।
Part heard. Item number 6 with 7, Torrent Minerals Private Limited and others versus Board of Trustees.
For the petitioner, Mr. Obrojit Mitra was arguing on behalf of the respondent. Now, maybe come back on next week any
Yes,
day.
adjournment is paid for on behalf of counsel appearing for the respondent. Stop. List this matter on 24th January 2024. Next. Yes, call on the other matter.
Also, but item number 4, Kanchan Oil Industries Limited and another versus Union of India and others.
The only place,
Yes.
the affidavit which has been affirmed by the FSI. This is an affidavit dated, affirmed on, my lord, 9th of October 2023. For the reason to demonstrate before lordship, my lord, it's a case of abject surrender of the scientific ideas and notion to the will and whim of the central government. They say that we are required to recommend the amendment of the regulations since the central government wants us to do so. And that is apparent from the report of the scientific panel.
You are placing the affidavit.
I am placing the affidavit of the the FSI affirmed on 9th October 2023.
কোথায় affidavit টা কোথায়?
Affidavit on behalf of respondent number 2.
Yes.
Page 13. Well, kindly take from page 13, where your lordship will find the report of the scientific panel constituted for the purpose of determining whether use of mustard oil in bevo would be pernicious to health or not. Now, my lord, now kindly take, my lord, panel recommendations. The panel considered, my lord has got that?
Yes, yes.
The panel considered all the comments received from and their the observations, recommendations as are under. The panel noted that the Government of India issued a direction on September 23, 2020 to bring specific regulation in to prohibit blending in mustard oil and to facilitate manufacture and sale of pure mustard oil for domestic consumption. This draft notification was issued as a consequence of this direction. The panel noted 487 comments received in favor of the proposed draft regulation and 34 comments received against it. Those in favor broadly argued that they prefer pure mustard oil to be available in the market. Permitting blending leads to possibilities of adulteration of MO, and that consumer should have a choice whether they wish to blend oils or rotate different single oils. Those against the proposed regulation state that blending leads to a better fatty acid profile, better
So,
omega.
Mr. Mojumdar, sorry. How are these comments received? They are put out in the public domain and then
No,
comments are
Malad,
invited?
we came to know about these comments only from the first affidavit used by FASAI. That certain observations were made, and these observations were made when the draft regulations were pending finalization.
Yes.
But those against the proposed regulation state that blending leads to a higher fatty acid profile, better omega-3 to omega-6 ratio, and that there is no scientific rationale for prohibiting blending of MO. While there is some merit in the arguments given by those opposing the new regulation, it is a fact that the overwhelming public opinion is in favor of prohibiting blending of MO. Further, the panel also notes Bevo category per se is not being prohibited, but only use of MO in Bevo is prohibited. This leaves the option open for those consumers who prefer Bevo. The panel is also of the opinion that it is still open to the consumers to either blend, this is from a scientific panel, edible vegetable oils or to rotate consumption of various vegetable oils at their own level. So they are permitting the domestic blending. The panel is of the opinion that it may be finalized as it is a direction from the government. And in the larger interest of discouraging adulteration, no charge of adulteration against any of the manufacturers, in the name of blending rather than on the basis of specific scientific rationale. So, this clearly indicates, my lord, the scientific panel acceded to the whims of the central government. In view of the above, the panel accordingly recommends draft notification for finalization that involves further approvals and also recommends giving sufficient time before it is made effective, as the draft states that the amendment would become effective from October 1, 2020.
Mr. Mojumdar, where are you reading from?
I'm so sorry, my lord. I'm so sorry. My lord, it is the 1, 2, 3, 4. Your lordship has got this comment of stakeholders and kindly take panel recommendations.
Yes, I've seen that. Which paragraph are you reading?
My lord, kindly take page 14.
Yes.
14. Kindly take, my lord. I read this last column.
Overwhelming public opinion.
Overwhelming public opinion, lordship will find.
Yes.
And then, my lord, kindly take, my lord, paragraph 8 in column, last column.
Yes.
Panel is of the opinion
Yes.
it may be fine as it is a direction from the government.
Yes.
As it is a direction from the government, and in the larger interest of discouraging adulteration in the name of blending rather than on basis of specific scientific rationale.
Yes.
So it is a clearly, this report indicates that it was all along the intention of the central government to prohibit use of mustard oil in Bevo, and all the exercise which was carried out from the very inception, that is constitution of the committee, thereafter passing an order under section 16, all these steps were in aid of the final outcome, that is to prohibit ban of mustard oil. And even the scientific panel had to accede to the will of the central government.
Yes.
But it reminds me of my lord Paulo Coelho and in Alchemist. If if there is a larger conspiracy around,
Yes.
then obviously, my lord, the minions have to yield.
And
that is
alchemist also with regard to blending and all of that.
blending and all that. Aqua regia. So, my lord, we come back on next day. My lord, any date, your lordship, my lord, only one difficulty. I have difficulty on 24th. If it is next week, my lord, I have no difficulty.
Yes, yes.
But 24th, I have difficulty, my lord. Because your lordship takes up these matters on Wednesdays, I suppose.
Yes, yes. Wednesdays, and I may also have been difficulty on 24th.
Yes.
Learned counsel appearing for the petitioner places the panel recommendations in the comment of stakeholders received on 10th November 2020 regarding prohibition of mustard oil in blended edible vegetable oil, mustard oil in BEVO, BEVO, capitals. Stop. Bolam ki will continue with his submissions. Yes, council will continue with his submissions on 17th January 2024.
Grateful, man. Grateful.